Morning. This is a convening of the Massachusetts Gaming Commission, the first one of the year. Today is Thursday, January 9th, 2025. It's approximately 9:34 a.m. We are holding this meeting virtually, so we will do a roll call. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Skinner.
Good morning.
Good morning, Commissioner Hill.
Good morning, I'm here.
Sorry about the order on that. And good morning, Commissioner Broder.
Good morning, everybody. I am here.
All right. So before we begin with Secretary Skinner, and in keeping with Governor Healy's request for today, we will have a brief moment of silence at 10 a.m. To remember the 39th President, James Earl Carter Jr. Peanut farmer from a dirt road in Plains, Georgia, a veteran who became President of the United States, despite being ahead of his time, a peacemaker who suffered a painful political loss. He went on to show us that we can all serve others and that everyone has inherent dignity. He was the definition of resilience through service. I will leave us with part of his favorite scripture from Ephesians, and be kind to one another, tender-hearted, forgiving one another. With that, I will turn it over to Secretary Skinner.
Morning again. So we have 3 sets of minutes to vote on this morning for the public session. And there was common attendance at each of those meetings, so I'll do one motion. And with that, Mr. Chairman, I move that the commission approve the minutes from the August 18th, 2023, December 14th, 2023, and July 11th, 2024 meetings that are included in our packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second.
Thank you. Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner? Commissioner Broder?
Abstain?
And I vote yes, 4 and 1 abstention. All right. Thank you, Secretary Skinner and the team as always. With that, we are going to turn it over to ED Serpa for an administrative update. Good morning, Dean.
Good morning, Chair Maynard. Thank you very much. And good morning, Commissioners. I think for this week's administrative update, I will just keep it short and sweet. I want to welcome the Commissioners and all the staff back after the new year and after what was a productive year. But more importantly, I know the team here is looking forward to working thoughtfully and with diligence on all of our important issues coming up for 2025, and I'm confident the agency will accomplish significant milestones in the coming months. We'll report just quickly that yesterday we got on our way with that. With our legal division did conduct the agency's required annual state conflict of interest review and training, which was an excellent presentation, really went well, and it was well attended, of course, since it was mandatory. But I do want to thank Councilor Grossman and his team for their work on that. And I think I can say we are already off to a good start for 2025. So that's my executive update, Chairman Maynard.
Thank you, ED Serpa. Commissioners, any questions for Dean? All right. With that, we are going to turn it over to item number 4. And for that, we will go to Councilor Grossman. Good morning. Happy New Year, Todd.
Oh, thank you, Mr. Chair. Good morning to you and to you commissioners, and good morning to all who are joining us here today. We have a matter involving Bally's before us this morning. You may recall a few weeks back, we actually were introduced to a transaction that they are in the process of or they are engaged with at the moment. We took a look at their trust agreement, and the commission, as you'll recall, approved that. Subsequent to that, we've taken a closer look at it, and Bally's has proposed an updated way in which we look at the transaction under the law. And they are here this morning to present their view. They may additionally advance an argument that a waiver would be appropriate in this case from our transfer of interest regulations. And of course, after they make their presentation, I would be happy to address any legal issues associated with the proposal. I know, of course, representatives from the IEB, both Kathleen Kramer and Caitlin Monahan, are available here. Bally's is represented here today by attorney Bob Ross, who will introduce the transaction as well as the team members he has with him here today. So without further ado, Mr. Chair and Commissioners, if it's okay, I'd like to turn this over to Mr. Ross. Good morning, Bob.
So,
And you are on mute as well.
Thank you, Councilor Grossman. It's very, very nice to be with the commission today. I thank the commission for the opportunity to present on behalf of Bally's. My name is Bob Ross. I'm of council at Greenberg Traurig, and we have the pleasure of representing Bally's in this matter. With me for Bally's are Craig Eaton, who is the Senior Vice President for Bally's Corporation. You may recall he's also the trustee in the trust agreement you looked at back in November, and James Valley and Brian Kelly from Nixon Peabody. We have worked extensively with commission staff, including Councilor Grossman and his colleague Deputy Council Hentoff, and Directors Monahan from the Bureau and O'Brien from Licensing, to provide information and answer questions about this transaction. And we very much appreciate their continuing collaboration. I'd like to introduce Craig Eaton to speak more about Bally's request.
Thanks, Bob. And thank you, Chairman Maynard and fellow commissioners. By way of quick further introduction, I'm actually a Massachusetts native, attended Boston College Law School. So it's a real pleasure to appear, I guess, in front of my home commission. So thank you. Thank you for having me. We're here with a simple request to obtain comfort that the transaction that we presented to this commission on November 21st, 2024, does not need prior approval. As you may remember, that transaction is a merger of two entities. The existing Bally's Corporation is a surviving entity, and Bally's Corp and Queen Casino become combined into one company, with Queen Casino becoming a wholly owned subsidiary of Bally's. So this new structure combines the holdings of Standard Rhode Island Limited and SGCQ Gaming LLC, along with any outstanding and rollover shares from Bally's Corporation. So we respectfully feel that prior approval to do this transaction may not be needed because subsection H of section 6 of the Sports Wagering Act, it only applies to the transfer of an operator's license. We only hold a temporary license, and we'll merely be adding new qualifiers that will be continued to be evaluated. So all information regarding these new qualifiers has already been submitted in conjunction with commission staff. Respectfully, we feel this is an efficient, common sense position. It will in no way result in the loss of important commission oversight because this commission retains the power to grant or deny the temporary license renewal and the operator license as it continues its evaluation. It's extremely important to us, to Bally's, to be able to close this transaction soon for many reasons, including financial terms in our loan agreement, which underpins the merger. And in this regard, just so you know, we're working in a very positive manner across the country with all applicable states and including this Commonwealth. And we truly appreciate all the work staff has done with us leading up to this hearing. We will continue to cooperate fully, obviously, in this licensure process, and we fully understand that we remain subject to the commission's power to either grant or deny our permanent license. And with that, we thank you for your consideration.
thank you, Mr. Eaton. Councilor Grossman, anything else before we open it up to the commission?
No, I think we can kind of move ahead. If the commission is inclined to entertain the argument that there's a distinction between a temporary license and an operator license under the law, we can talk about that a little bit. But I think there are other alternatives here to consider as well that we might want to put on the table for consideration before we just address that one issue. I think there are legal issues associated with that interpretation of the statute that I would not necessarily subscribe to, but it is obviously the argument they're advancing at the moment. So if you would like to consider that first, you can. But I think you'd want to maybe lay out all of the options before diving deeply into whether there is a meaningful distinction between a temporary license and an operator.
I appreciate that, Todd. Can we go through any of those other options?
Yeah, I'm happy to, Chair Maynard. The effectively the same result, which is really what's important here can be accomplished by granting the waiver that was requested by Bally's on October 14th. The result is the same in that that waiver request proposed that the review of this transaction take place in the context of the application process. And that's, effectively the same result that would occur out of the legal argument that we've just advanced. The idea being that if the transfer of interest provision is considered to apply, then the efficient way to accomplish this review in light of Bally's pending application for an operator's license, as well as the upcoming request Bally's for a renewal of a temporary license. We've received our materials from Director O'Brien, and that is ongoing because the anniversary of that is February 23rd. In both those contexts is an opportunity for the commission to review new qualifiers and to, indicate, as Craig subscribed to, that commission has the full power to grant or deny those licenses, both the renewal of the temporary license and the operator's license. And so effectively, whether you call it a waiver request or whether you agree with the legal interpretation that's been advanced, the result is the same. Bally's would ask that this be handled through the pending application processes. And so that's and the waiver request, I'm happy to review the legal standards for a waiver request. Bally's, I believe, meets all of those, which are applicable because of the fact that there is a pending application process. Those criteria are that granting the waiver is consistent with the Sports Wagering Act. For the reasons we advanced in the request, as well as today, we believe it is consistent with that. Granting it will not interfere with the ability of the commission or the Bureau to fulfill its duties. That is for sure the case here. In these pending application processes, the commission has every opportunity to investigate Bally's and its qualifiers. Granting the waiver or variance will not adversely affect the public interest. We strongly believe that to be the case here because there is no loss of commission oversight, and not granting the waiver would cause a substantial hardship to Bally's, and we believe that's true for the, among other things, the financial terms that Mr. Eaton referenced. And so we believe that we also satisfy the criteria for a waiver. And the result of that would be the same as procedurally as the result that would come from being advanced under the legal theory that was described. And so for that reason, fundamentally, what Bally's asked for is for these new qualifiers to be evaluated through the pending application processes.
Thank you, Councilor Ross. Councilor Grossman, anything to add, or is this a good time, commissioners, turn to the IEB to ask them what they're thinking?
If I could I'll jump in for one more second just to help calibrate the discussion. Then I think it would be helpful to ask Director Monahan to jump in. It's important to remember the language in Chapter 23N, Section 6H. That's, I think, what most of this discussion revolves around. And it says that no licensee shall transfer an operator license or any direct or indirect interest in the license without the majority approval of the commission. Unlike Chapter 23K, Chapter 23N, which is where we're residing right now, where this is a sports wagering entity, does not really add any further texture or direction as to how the commission should go about evaluating a transfer of interest. And so what the commission did, you'll recall, is created a series of regulations in 205 CMR 229 that outlines the transfer of interest process for a sports wagering operator license. And the waiver request that is being advanced would be a waiver from those regulations. So essentially, the commission under this particular proposal could make a finding that this is a transfer of interest under Chapter 23N 6H, but as Mr. Ross and Mr. Eaton have outlined, the regulations themselves could be waived such that some of the procedural steps that are required, and we're talking about things like interim authorization and what have you, could be waived for now, given that this particular entity, Bally's, is under investigation by the IEB as part of the durable suitability process. And the commission will be, of course, looking at the entities in great detail in the near future. So any waiver would simply be from those regulatory requirements, not from the idea that this is, in fact, a transfer of interest. Now, the first argument that Mr. Ross, I think, advanced was more of an argument that 6H doesn't apply at all. So it's not a transfer of interest. And that's a different way to approach this. The issue I would just suggest with that is that most of the statute 23N and regulations use the term operator license or sports wagering operator license to describe the duties and obligations of all of the licensees at the moment, including temporary operators. So to draw that distinction for these purposes, i.e. that Section 6H does not apply in this situation, may be to find a distinction to give us comfort here. It could open up a can of worms, so to speak, and create a bad precedent for us. One of the other options would be simply to review this matter as a transfer of interest with all the attendant processes under 229 and move forward there and to not allow the waiver request. So those are three of the options. Again, to recap, that it is a transfer of interest, but you grant a waiver from the regulatory provisions and approve the transaction using a slightly different process. Consider it to be a transfer of interest and keep all of the attendant processes in place. Third, to adopt the interpretation of the statute that Bally's has advanced, that there is a meaningful distinction between the term operator license and a temporary operator. So the transfer, this is not a transfer of interest under Section 6, and the new entities can just be reviewed under our new qualifier processes. So I think those are three of the main options, and I think it might be helpful to allow Caitlin to jump in here offer some further perspective before you engage in any deliberation.
Thank you, Councilor Grossman. Director Monahan, good morning.
Thank you, Chair. Good morning. So as Todd just explained, there are three options on the table right now at this moment, and I'm happy to walk through each of them from the IAB perspective. I will start with I have as the first option, which is, this is a transfer of interest. The statute and the regulation apply, and so we go through the normal process. Obviously, that is standard. The IAB would be very comfortable with that. It gives the IAB the opportunity to review the transaction and the entities involved in the transaction before the transaction closes, and for the commission to also have that look into it. Of course, however, that means that the transaction wouldn't be able to close by the deadline that Mr. Eaton talked about. That's the first option. The second option is that this is a transfer of interest. The commission determines that 6H does apply, so it does not find a distinction between an operator and a temporary license. But based on the facts before us, the commission allows a waiver from the requirements of 205 CMR 229. So in that instance, the IAB, I'll give you the bottom line first. The IAB would be comfortable with that because of the following facts. We are in a situation with Bally's where the facts of the transfer are that the individual who is going to be basically becoming the majority shareholder of Bally's, Mr. Kim, has been preliminarily reviewed by the IAB. So he has gone through preliminary suitability. There are additional entities related to that transaction, not individuals, but entities that have not been reviewed as a part of preliminary suitability. But we believe that because the investigation is ongoing, all the application materials for those new qualifier entities are in. We are actively reviewing them, and we will be, getting to durable suitability in the not terribly distant future. We believe that there would be a low level of risk to waiving the 229 requirements in this particular instance. That said, and we can address this at the end. The commission, if the commission goes with this option of waiving 229, the statute still does apply. So the commission does still need some level of approval of the transaction before the transaction can take place. But I'll put that on the side for a moment until if the commission gets to that part of the conversation. The third option is that the commission determines that this is a transfer of interest. I don't really think there's any question there. Everyone agrees that it's a transfer of interest. However, 6H doesn't apply. So the commission agrees with the argument that an operator license or a temporary license are different things. And therefore, because 6H doesn't apply, 205 CMR 229 doesn't apply, and therefore this would be treated more like just adding a qualifier to the application or to the application. So the qualifiers would be reviewed along with durable suitability. That option, the IAB has looked at the law. There's a colorable argument that there's a difference between an operator and a temporary license, but there are potential pitfalls to making that determination, as Todd explained. However, if the commission went down that road and we treated the new individuals and entities as qualifiers and reviewed them as part of durable suitability, again, the IAB would be comfortable with that in this instance where we have looked at Mr. Kim and everything is underway. So with that, unless there are any questions, I will pause.
All right, Director Monahan. Commissioner Broder has his hand raised. Commissioner Broder?
Sure, I'm hoping this can almost be a little bit of a table setting for a more specific Q&A, just to put a couple of thoughts out there, a couple of my concerns maybe. I'm not at all comfortable using this particularly and hopefully fairly unique set of circumstances to make a call about a distinction between temporary operator and permanent operator, because the interest in doing our best work in terms of advancing the interests of consumers and doing our due diligence is important across the board. That having been said, I am not hostile to the waiver for the somewhat unique circumstances that IB Director Monahan just went through about the facts and circumstances of this situation. One thing I do want to hear a little bit more about, though, is one of the justifications for moving on this is essentially the financial consequences to the players, to Bally's. But Bally's structured the transaction, right? So they created this mess to a certain degree, potentially, by the way this is structured. If I was a more sophisticated person in mergers and acquisitions and corporate finance, I might understand it a little bit better, but I do want to hear a little bit about that as we continue the discussion.
So Commissioner Broder, this is actually 9:59. So with that question out there, I would like to get ready and take a moment of silence for President Carter, please. It gives everyone a second to think about the answer to that question, right? Let's take a moment, please. Thank you. All right, Commissioner Broder, please, was that the end of your question?
Yes.
Okay. All right.
Chairman, I'm happy to start the answer, and Craig Eaton can jump in as well. Commissioner, the January 21 deadline that we're talking about is a condition of the loan agreement, as Craig Eaton said, that underpins this. This was not something that like Bally's arbitrarily created. It is a result of the transaction that it entered into with its lender. And that we informed the commission about that, about this transaction on the day that it was announced, which was July 25th, 2024. And so that's where the deadline came from. And it is not something that is a result of that Bally's did on its own. It's a result of the lender's interest in wanting to be sure this closes efficiently. Craig, is there more to say about that?
Not much more. It's just that, this is a commercial transaction, a merger, which was done quite a bit ago, like you said, Bob. Normal loan terms. There's a ticking fee that kicks in on January 21st. Unfortunately, this is how it goes when you're negotiating these loan deals. We certainly we're not presupposing that every jurisdiction, including Massachusetts, would just bless this. So I don't want to come across with any type of arrogance or in that way. We have to get approval from, I believe it's 17 states. I have that wrong, but it's about 17, including the UK. So there are a lot of moving balls here, and it's just the nature of our transaction. So it would be very, very helpful to the company to be able to close this. If not, we start incurring financial penalties that start really building up. And the only thing I will say is that I just want to add that this is very unique in my mind, at least in the sense of this quote transfer, and I understand what it is truly to the same entity in person. I know they're separate names, but it is all Sue Kim. It's Standard General. And so there's really not going to be any difference per se. It's going to be the same officers at Bally's. It's going to be the same board. It's going to be the same chairman of the board, which is Sue Kim. And at the end of the day, it's going to be really the same owners, even though I understand we have certain entities within his investment firm that are being looked at.
I very much appreciate the that explanation. It's very helpful to me. I hope I didn't suggest that anything nefarious was going on by any stretch. I do certainly want to let other folks that might be out there recognize these are complex transactions. Don't try to leverage a transaction to, put the commission in a spot where we have to make a series of unpleasant choices, perhaps. But I do appreciate the explanation. I'm also.
Thank you. Thank you. And it certainly was not our, and thank you. Thank you.
Thank you, Mr. Eaton. Thank you, Commissioner Broder. Commissioners, anybody else have questions? Commissioner O'Brien, I see you reaching for your mic.
I don't have questions, but my thoughts is along the lines of Commissioner Brothers, which is I do not accept the argument that in this little area, you're going to treat the definitions of operator differently. I just don't see backup for that in the statute. I also think it's a slippery slope. And, trying to create bad law and interpretation based on a peculiar set of facts. I'm open to the idea of the waiver, most particularly because of IAB's representation that they feel comfortable with it and the de minimis risk and the peculiar situation, as you pointed out, that it is an owner who's already been deemed preliminarily suitable. I did have a similar but slightly different question to what Commissioner Broder said, which is understanding you structured it the way that you did back in July, knowing what you're facing now. Are there avenues, and to the extent you cannot discuss them in public, I respect that, but are there avenues of restructuring that would remove us from this position of having to kind of make a waiver for you rather than you guys going through the normal course and us not having to have this discussion?
We have absolutely looked at that, and there are no reasonable avenues, to be very frank.
Okay.
We appreciate that.
Okay, and that's impactful to me, to be honest, is the due diligence in trying to see if there was a way to restructure. I appreciate that. Thank you.
I join Commissioner O'Brien and Commissioner Broder's sentiments. Commissioner Hill, and then I saw Commissioner Skinner. Whoever wants to go first.
Commissioner Skinner, be my guest.
Thank you, Commissioner Hill. I am aligned with Commissioners O'Brien and Broder. I too hesitate, or I have serious concerns rather, with the legal implications of us drawing a distinction between a temporary license and an operator's license per the language of the statute. I am very much interested in seeking granting of the waiver, but with some additional conditions. And so it is not necessarily a complete waiver of the regulations 229, but I want to, once we decide how to proceed as a commission, I'd like to have a discussion as to what those conditions would look like and what IEB's capacity is to get us some additional information relative to those qualifiers prior to the time at which we are to review durable suitability for Bally's. And I am comfortable in doing that. I am relying on the IEB's comfort level in granting this waiver, but I'm also very much relying on the limited circumstances that have been presented to us in terms of this transaction, in terms of the parties, the qualifiers that are involved. And I do want to emphasize that this is not a blanket application of how I intend to review these transfers going forward. It is really just a matter of looking at what we have in front of us. Very much respect and appreciate your being forthcoming relative to the financial implications for Bally's if a waiver is not granted here. And so I hope that, and it sounds like we have consensus, at least I hope we can get to a place where we are granting, again, a limited waiver of certain sections of 205 CMR 229.
Thank you, Commissioner Skinner, and I agree with you too. Commissioner Hill.
So when you speak last on an issue, there isn't a lot more that you can say unless you're not in agreement with your fellow commissioners. So, Mr. Chairman, I am leaning toward the request for a waiver on this as well. And I think that would behoove us to go in that direction with all the options that have been put before us today. I can certainly give you reasons why I think we can do that, but I think they've been articulated by my fellow colleagues already. So for the record, I think giving the waiver from the transfer of interest is the way we should probably be going today.
Thank you, Commissioner Hill. I do have a couple questions myself. I will ask Director Monahan or CC Kramer, whoever from the IB wants to answer. Preliminarily, we have looked at Mr. Kim, correct?
Correct.
Do we have, and I will ask this question very narrowly for the record. Do we have any information before us today at 10:09 a.m. on January 9th, 2025, that gives us any hesitation or pause as to their temporary license, which they already have right now?
No, Kathleen, please jump in if you have any.
No, I agree with you, Caitlin. I don't have any hesitation at this point.
All right. Those are important questions for me. Okay. With that, commissioners, I think we've gotten to a part where we believe that we can get to the waiver because this is a narrow circumstance of the same person getting to the same place. And we're not going to always look at this reg the same way, depending on the facts, as Commissioner Skinner artfully articulated. Were there any conditions that we wanted to add?
Mr. Chairman?
Commissioner Hill.
So I know we had discussed this. So I have two. I think the licensee certifies that they know of no reason why any qualifier would be deemed unsuitable. I think that should be a condition in the motion if we were to make that. I also believe that the previously executed trust agreement remains in effect and utilized as contemplated. I think that should be a condition. And I think those were the two that I had, and I can't think of any others that I would add.
Thank you, Commissioner Hill. Commissioners, do we have anything else we would want to add to that, given our discussion today? Commissioner O'Brien.
The only other thing I would consider, and I ask IB this question, is whether we should have a date certain expiration on the waiver.
I just want to make sure I understand, because once the waiver happens and the transaction closes, that's my understanding that we ended it. So are you looking for something else in that period? Is that?
So I contemplated this waiver more to the effect of because temporarily it couldn't happen and have your adjudication wrapped up in time. I'm viewing this waiver more as time to allow this to close on the business side and give you guys time to do what you need to do under what it would have been the transfer of interest time frame. So I sort of contemplated this going through the expiration of the normal clock on the transfer. And that if for some reason something is beyond that, they don't finish, et cetera, aren't we in a different place?
If everything doesn't happen as they're describing today by January 21st or 22nd or something.
Yeah.
Is that the question?
Yeah.
Yeah. I think if anything.
I mean, maybe that's just a condition that's added on with more specificity.
I mean, if anything materially changed in the transaction, we would definitely want to know that, because the waiver is based on the specific facts of the transaction. So I think that's a fair condition, is that if there's any material change here, we would want to know immediately. And
right.
Transaction couldn't go through until the commission heard about it.
Right, right. So however, whatever wording, whether it's, within 24 hours notification to IEB of any material change in the anticipated, transaction on the 21st, whatever the language should be, but I would want that in there as well.
Can I jump in? Sorry, I don't know if it's my place, and I apologize. So the 21st is absolutely the date we're shooting for, but we do have other states, right? So there is a chance it could drag a few days past that.
So, I mean, how January 31st, that if it isn't done by that date, that it has to come back or go to IB is to alert us. I mean, it is a very peculiar set of facts getting to a very unique waiver. So
I'm
I'm
being
not trying to
selfish
be
here.
unreasonable, but if we can work on a reasonable compromise date.
Mid-February, just in case?
Okay.
If I can
I'm
suggest
comfortable
a
with
date, I'm sorry, Commissioner, I can also suggest the date of February 23rd, which is when the existing temporary license expires. That's a sensible kind of, threshold for that I think, you know, there's that may serve at that purpose that you described.
Okay. I can work with that.
Mr. Chairman?
Yes, Commissioner Skinner.
Commissioner O'Brien's concerns, but I come at it, I think, a little bit differently, and I alluded to this earlier in that I'm wondering if we could have IEB continue with their interim process such that this commission would receive a report relative to the transaction and all of the qualifiers, as we would had we not been had we proceeded without a waiver with any conditions. I think that it's important for me to get whatever information is out there as soon as possible. And I understand that there is some level of efficiency in waiting to roll this investigation into the durable suitability investigation, but I think that leaves too much time between between today and when the transaction closes and even beyond, if we don't come to some sort of understanding as to when it would make sense for a report back to the commission. And so I defer to IEB in terms of its capacity. I do think that the IEB was proceeding with this review as though 229 would apply in its entirety. And so I would like to see, as one commissioner, that process proceed, again, with the understanding that the pre-authorization is being waived. So in my mind, that's the only piece of 229 that I'm interested in waiving.
Sure, to respond, the IEB could certainly continue with the investigation it was undertaking with regard to interim authorization. I might ask for a little flexibility in the 90 days, if that's okay. Just because hard deadlines are always hard, and if it's not strictly necessary, we may ask for a little bit more time, not a lot more, but we could absolutely continue with that process if that was the wish of the commission.
That says one commissioner, and I wouldn't be opposed to granting the additional time. I think you have, under the regulations, another 3 months upon request, right, available to you, if I'm remembering correctly.
That, I think that was for final.
Okay.
But yeah, if you're out from under 229, the 90 days wouldn't be in effect anymore. So yeah, we would just ask, and we can come back to you, right? We can circle up and say, you know, what's a date that we think we could reasonably get that to you by without sort of burning the midnight oil.
I'll remind everybody, Commissioner Skinner, that's a good point, but we're in this position a little bit because we couldn't do the full suitability in a certain amount of time frame. I am interested, like you, to see the update. You know, I'm wondering if instead of that full report that we'll get was durable suitability, even if we just get a memo update, would be, to me, helpful to even understand where we are in the process. You know, I had to think about this. I had to draw this out on a whiteboard in the fall when we first heard about this. And, you know, the way I look at it is this, Mr. Kim, I'm a very simple guy, right? 28, he's got a certain percentage, right? And he's driving this car. And now he wants to own more of the car. And if he's, you know, if he's a good driver right now, he's a good driver at this percent or that percent. And if he's a bad driver right now, he's a bad driver right now at this percent or that percent. And so that's how I'm having to get to this waiver. And that's why I think it's a narrow circumstance. But that said, I'm just explaining kind of where my brain had to go to get there. If it's helpful for anybody else.
For me, I think there are new qualifiers that we haven't been briefed on, or that haven't been investigated rather, as part of the preliminary suitability process. And so I'm just unwilling to not receive any information whatsoever, despite the common qualifier, individual qualifier in Mr. Kim. I'm unwilling to wait until durable suitability in order to get information about those qualifiers. Bally's was the last operator to come online. And so I would assume that they would be the last durable license that we consider. So I think that's just too much time. And I mean, my proposal is out there. I think at this point we should try to reconcile it with what Commissioner O'Brien has proposed, given that, you know, we all share the same concerns.
Kathleen, I see Kathleen's mic's off.
Yeah, I was just going to suggest, I wonder, Commissioner Skinner, would it be helpful? Of course, the commission has seen some of the reports that the IAB has done before in terms of preliminary suitability on a transfer of interest. Would it be helpful for us to submit at some point a preliminary suitability report for the new entity qualifiers? Because Mr. Kim obviously was looked at the first round. We could provide an update as to his status. He, you know, has to continuing duty to report to the IAB right now. And he's undergoing the durable suitability investigation, but perhaps maybe we could do a preliminary suitability report specific to the new entity qualifiers. So that would come to the commission before the durable suitability investigation. Is that something that might be helpful that we could do and provide, you know, the deal could close, the commission could waive the provisions of 22029, but the IAB could still provide the commission with a preliminary suitability report in the hopefully not too terribly distant future with respect to the entity qualifiers that came out of this transfer of interest. Is that something that might work?
Yeah, that works for me. And with the understanding that we are not dealing with the 90-day time frame, right? I get that. But I think that whatever additional time between the 90 day, beyond the 90 days, excuse me, that the IAB would need to produce that in a reasonably timely manner, then that works.
I join you on that, Commissioner Skinner. Commissioner O'Brien.
So I know we haven't heard from Commissioner Hill and Commissioner Roeder on the most recent request for condition, but I mean, I think there's three of us that are in agreement at minimum. Given the particularities of this, I'm actually wondering if legal could, while we move on to other things this morning, and then come back as soon as possible, delineate for us what these conditions are so that we can move on this morning, hopefully this morning, to make sure everyone is satisfied with the conditions we've talked about. It seems like there's four. The two that Commissioner Hill raised, the timing issue that I had raised with the net proposed February 23rd date, and then Commissioner's Skinner's request for essentially preliminary suitability reports under a reasonable timeline on the new qualifiers.
That's fine, Commissioner O'Brien. We can add. I have the three. I just have to add Commissioner Skinner's additional condition, and I can work on that while I have the next item in the schedule. But after that, I can go back, add the condition. We can come back at maybe towards the end of the meeting and vote on this, if that makes sense.
I don't want to hold up people's day on that one. I didn't know if it was something that if we can do it reasonably, I think that's.
We can do it pretty. I can do it pretty quickly. Yeah.
Okay.
I'll let everyone know.
Commissioner O'Brien, with the exception of the fourth one, which I've been writing down these, I'm actually ready to make a motion with the conditions already in place. But if Justin,
can we have 2 minutes for Commissioner Hill, since you are ready to maybe circle with Justin?
Yeah, that's what I was going to ask. Maybe run it by Justin, and then unless he sees a needed change, then we can move.
Let's take a 3-minute break.
Sure.
How does that sound?
Yeah.
Okay.
All right, thank you. All right. Give everyone a second to get back on.
Mr. Chair, may I ask for one more minute?
All right. Yep. Absolutely.
Thank you, Mr. Chairman.
All right, Connor, I think we can pull this down. This is a reconvening of the Massachusetts Gaming Commission. Give Paul a second to get back. All right. This is a
Sorry about that.
no problem. This is a reconvening of the Massachusetts Gaming Commission. We are holding this meeting virtually, so we will do a roll call. Good morning, still Commissioner O'Brien.
Good morning.
Good morning, Commissioner Hill.
Good morning.
Good morning, Commissioner Skinner.
Morning.
Good morning, Commissioner Broder.
Thank you. As those who are led by the Spirit of God.
And I'm here. Just to recap where we were, we've had a conversation with the council from Bally's. It was a robust, thorough conversation about 205 CMR 229. We had questions from the commission that were answered, and Commissioner Hill was thinking about moving and wanted to get some clarification with council before doing so. So with that, commissioners. Commissioner Hill?
I was gonna say, can we hear the proposed language?
Yep. I'll read it and then you let me know if we want to make any changes. Is that appropriate, Mr. Chairman?
I think that makes sense, Commissioner Hill.
So the language I would have is I would move to grant a waiver to Bally's Interactive LLC from the provisions of 205 CMR 229 as consistent with 205 CMR 202.032 and 205 CMR 102.034 as granting the waiver or variance is consistent with purposes of MGL Chapter 23N, and that granting the waiver or variance will not interfere with the ability of the Commission or the Bureau to fulfill its duties, and that by granting the waiver or variance will not adversely affect the public interest, and not granting the waiver or variance would cause a substantial hardship to the entity requesting the waiver or variance. And then I would further move that the waiver would be subject to the following conditions. One, that the licensee certified that they know of no reason why any qualifier would be deemed unsuitable. Two, that the previous executed trust agreement remain in effect and utilized as contemplated. And three, that this waiver be in place through February 23, 2025, as discussed here today. And four, that the IEB provide an update on preliminary suitability or provide a preliminary report relative to Bally's by April 10th, 2025.
So the only language that I think might be needed to be added in there is that February 23rd bullet is that Bally be under an obligation to notify IEB within 24 hours of any material change.
Is that an amendment, Commissioner O'Brien?
Well, he hasn't moved yet, right?
That's correct. That was a proposal.
So that's
Okay.
proposed to do that. And then if that can be what's read in on the motion, then I'm
All
fine.
right. I was just trying to save Commissioner Hill's vocal cords.
No. So can you repeat that, Commissioner O'Brien, what you would like to see added? So as discussed here today and further,
That Bally's notify IEB within 24 hours of any material change in the proposed transaction.
And further, that Bally notify IEB. Say it one more time, I'm sorry.
Commissioner Hill, I just sent it to you.
Thank you kindly.
Thank you, Justin.
No problem.
My only question is, where did the April 10th date come from?
That's 90 days from today.
Okay, 90 days from today.
Yep.
And Director Monahan, is that in line with what you were thinking in terms of your ability to get this completed?
Yes, thank you. The original transaction date when we started the 90 days from it was going under June 29, was I believe December 13th. So that brought us into mid-March. So giving us those additional weeks if necessary is very helpful. We appreciate that.
Thank you.
Good time to remind the public that we have to do our work in public.
Mr. Chairman, I am sitting here patiently waiting to see if there's any other comments from, through you, from my fellow commissioners, or should I read a motion?
Commissioner Hill, I was patiently waiting on you to potentially move.
Okay.
So this is a motion.
This is now a motion.
All right.
I move to grant a waiver to Bally's Interactive LLC from the provisions of 205 CMR 229 as consistent with 205 CMR 202.032 and 205 CMR 102.034 as granting the waiver or variance is consistent with the purposes of MGL Chapter 23N. 2, granting the waiver or variance will not interfere with the ability of the Commission or the Bureau to fulfill its duties. 3, granting the waiver or variance will not adversely affect the public interest. And 4, not granting the waiver or variance would cause a substantial hardship to the entity requesting the waiver or variance. I further move that the waiver will be subject to the following conditions. The licensee certifies that they know of no reason why any qualifier would be deemed unsuitable. 2, that the previously executed trust agreement remain in effect and utilized as contemplated. 3, that this waiver is in place through February 23, 2025, as discussed here today, and further, that Bally's notify IEB within 24 hours of any material change in the proposed transaction. And 4, that the IEB provide an update on preliminary suitability or provide a preliminary report relative to Bally's by April 10th, 2025.
Second.
Thank you. Commissioner O'Brien.
Distances have a way.
Hold on just one moment, Commissioner Berger. I believe probably President Carter's services are coming through.
Yeah.
In the
Oh, my
background.
God.
So with that motion and second, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and Commissioner Broder.
Yes.
And I vote yes, 5-0. Thank you to Bally's. Thank you, Councilor Ross and Mr. Eaton. Mr. Bally.
Commissioners, we're very grateful for this action being undertaken so promptly and the thoughtfulness you've applied to this. And we will continue as we have to collaborate enthusiastically with the commission staff as needed.
Thank you, and we appreciate it. All right, we are now going to turn it over to item B, sub-item B, which I understand we have some time constraints on, so I'll kick it right over to, I see Justin's mic's off.
Good morning, Mr. Chair and Commissioners. This is a return to a regulation that we had previously discussed November 7th, 2024 at a public meeting. This is 205 CMR 23812, which are the additional uniform standards of accounting procedures and internal controls for sports wagering. As you may all recall, we had a substantive discussion back in November on the letter of credit requirements. A number of different options were proposed for commissioner consideration. There was a robust discussion and a request that we put the regulation and the potential options out for informal comment from both the public and from our operators. We received a fairly good response. We got one public comment. We received comments from several of our operators, and I also connected with the Attorney General's office over the phone, and then they submitted a written comment as well. So this is back before you with some additional options to consider, plus the original 3 that had originally been considered. And just for sort of a brief summary of what the commentary was, we had one public comment that indicated that they felt strongly that the funds that being protected should include not only liabilities in play, but also the funds in the account. You may recall that there's a question about whether the letter of credit should cover only active liabilities or active wagers, or in addition, should it also cover funds being held in a sports wagering account. The licensee comments we received, I'll go through the ones we received just briefly for your edification. They're also in the packet in the memorandum that we updated here. But Bally's agreed with the public commenter and voiced preference for expanding the letter of credit coverage to include funds being wagered and funds held in sports wagering accounts. We received comments from MGM Springfield. MGM Springfield did not support the letter of credit requirements to cover retail future wagers, given the overall sum of the wagers is more than insured by daily operating cash and cash equivalent reserves. So they had a preference for sort of the managing that via daily cash reserves. Fanatics made a comment coming back, noting that they support the regulation in its current form, given the commission's insight into their daily financials of our operators. They did request clarification on how operators should calculate the letter of credit. However, FanDuel sent us a letter and a redlined version of the regulation, noting that they also preferred a daily cash reserve method of managing this risk. DraftKings reached out to us, sent us again a redlined version of the regulation, noting that they prefer keeping the original regulation in place while also requesting the ability to back up reserves with a surety bond. And then the Attorney General commentary was they preferred a mechanism that would protect both the liabilities in play as well as account funds in the event of a sports wagering operator going out of business. They did not indicate a specific preference for what financial vehicle to do that with. They just noted that their preference was, the sort of the greatest range of protection for Massachusetts consumers, and that their letter is attached here. I will note that we also received a late comment from BetMGM. I think it was late in the afternoon, Monday. They also suggested that they preferred a daily cash reserve management solution to this type of issue. So the options that are sort of on the table today, and this is by no means an exhaustive list, but are the original 3 options, which would be maintaining the regulation as it currently stands. The second option would be expanding the scope of the letter of credit requirement to include not only the liabilities in play, but also the amounts in the sports wagering customer account. The third option would be to require the letter of credit only for the amounts being held in the account and not for the liabilities or the active bets in play. And then the fourth and fifth option of those presented by FanDuel and DraftKings, respectively, the fourth would be allowing for daily cash reserve management to replace the letter of credit requirement. The fifth would be to allow for a surety bond. And I'll note just for the record as well, these are 5 options. I mean, using your imagination, you can come up with other options or permutations or combine some of these options to provide an opportunity to do one or another. So there's flexibility here depending upon the preference of the commission. But I'll note that I believe Derek's on the call, and so is Mina Macarius from A&K. If there's any questions about the specifics surrounding these different financial instruments, and I would defer to their expertise on those.
Thank you, Councilor Stipic. I want to be clear about when I said there's time constraints, it's actually on our outside counsel, not on the issue itself. So, Mina.
And Mr. Chair, just to be clear, my time constraints are for about another hour, so I have plenty of time, I hope, but we'll see.
Perfect. All right. So, commissioners, we've heard Councilor Stipic lay out pretty artfully some of the choices we can make. Questions, comments? Commissioner Broder, I see your mic's off.
I also just try to start the discussion. I appreciate the robust range of opinions and options, but my current thinking is that we should maintain the status quo in terms of recognizing the nature of the protections that are currently offered. Some of the questions around the things we can do and how efficacious they would be in layering on additional protections when it's not clear to me that it's really a heightened risk. And while we do treat everyone fairly, I try to be a little bit mindful as part of our responsibility. I think our primary responsibility is certainly consumer protection, but we do recognize, right, there's a bit of a balancing act here, and you want to do things that are effective and cost effective. And I worry about sometimes adding costs that might affect different operators differently. Some of our operators are very heavily resourced, and some less so in terms of their ability to make these kind of investments. Now, don't get me wrong, there are certain baselines that have to be done, but I don't want to see us in a situation where we create problems where maybe smaller players, I'm not sure they're really truly smaller players, get at a competitive disadvantage because they have a different set of financial resources. Again, that is secondary to consumer protection 100%. But that's just kind of my opening thoughts about what we might want to do here.
Thank you. I appreciate that. Commissioner Skinner's mic is off. Commissioner Skinner.
Commissioner Broder, I feel similarly. For me, this is classic. If it ain't broke, don't fix it. But at the same time, I do place more of a priority on safeguarding the money in the player accounts, right? That is money that belongs to the player. And the reason I place more of a premium on protecting those funds is in terms of the liabilities, amounts wagered, those are amounts that patrons were prepared to risk in the first place. And that's not to say that those funds don't deserve or that they deserve any less protection. I think both aspects are worthy of consideration here. But like you, it's important that I balance all of the considerations, and I do certainly want to give as much deference as possible to consumer protection. Grateful that the Attorney General's office did weigh in on these options, and right now I'm leaning towards option number 3, and that is to reverse what currently exists in terms of what we require be backed up by a letter of credit. I think that I know that our team has already deemed what is existing to be adequate, in that it does provide the requirement for a letter of credit. Correct? Yes. And so I would be interested in seeing just the reverse of that, meaning again, requiring the letter of credit for player accounts rather than the liabilities here, wagers.
Thank you, Commissioner Skinner. Commissioner Hill.
I just want to be, I am more in line with Commissioner Broder, but I do know there's some concern that the Attorney General's office did bring to our attention. And I want to make sure that, even though I'm leaning toward leaving our regulation as is, I do want to hear from our legal counsel. Do they agree with the with the AG that we need to clarify the language so that our consumers and operators truly understand what we're asking for.
Commissioner Hill, I can address that. So one of the comments made in the AG's letter was to provide a definition of sports wagering liabilities, which I agree we could certainly do that. I that's a term of art which I think people in the industry are familiar with, but it may not be readily apparent, and there's not a definition of that term in the definition section. So we could absolutely draft a definition for that. I mean, the AG's, I think the main thrust of their letter is that they prefer more protection over less protection for our consumers. They don't specify whether, that should be a letter of credit or handled via surety bond or handled via daily cash reserves. They don't get into that level of detail. They just indicate that they have a preference for protection of, more protection for both the active wagers as well as account funds. So they sort of, I think that, is an implicit deference to the commission to make the decision of how we want to protect these funds and which funds we want to protect.
And again, I'm leaning toward the language we already have in place, but if we could clarify, as has been asked, I think I would be comfortable with that as well.
Thank you, Commissioner Hill. I see Commissioner O'Brien's mic's off.
So I am in alignment with Commissioner Skinner's take on this, which is option 3. I think more appropriately maintains the status quo, but addresses what I think is a deficiency in protections for the consumers who put their money in there. Whether, as Commissioner Hill just said, that could be effectuated by amending the definition and leaving the other language alone versus changing it, I'm open to that conversation, but I'm pretty forcefully behind the idea that we need to make sure the monies that has been put in there and not risked needs to be protected.
Thank you, Commissioner O'Brien. I do have a question, Councilor Stivic. There was a conversation in the materials regarding, just give me a second, the surety bond. Did the Attorney General's office have any opportunity to think about the surety bond option? Because I, like my fellow commissioners, you're going to hear the same thing from me. I definitely understand where the Attorney General is coming from, and I'm trying to get creative on how to be more protective. But as Commissioner Broder said, to balance the interests that we have to do statutorily as commissioners of balancing the act, right? So.
Yeah, so we did not provide the specific input we got from our operators to the Attorney General's office. This was kind of all taking place at the same time. So we were getting comments from operators, and that was running in parallel to us speaking to the AG's office. And given the fact that the AG's office didn't indicate a specific preference for protection, I don't know if they would have an opinion on a specific financial instrument on managing this level of risk, because they didn't comment on letters of credit in comparison to anything else. And that was an active point of discussion in our original conversation. And they were aware of that because that happened before I spoke with them and before they drafted this letter. So to answer that more succinctly, Mr. Chair, I don't know if they'd have an opinion or if they would offer an opinion on what type of financial instrument they would prefer, or if they have a preference on a protection, and whether it be surety bonds, daily cash reserves, letter of credit.
Okay.
Mr. Chair, we were asked to look into that issue a little bit after the last meeting, so just to follow up on it. I think just to recap sort of the distinction between the different instruments, the value of a letter of credit really comes through relative to cash reserves in bankruptcy because it can be called on. Otherwise, the availability of funds is essentially the same, right? Because the money is there. It's really when a bankruptcy happens that a letter of credit has the most advantage because it can be called on immediately by the gaming commission to pay account holders, right? Depending on what you're setting it for. The surety bond, I would say, is somewhere in between the two. Surety bonds are like insurance policies. And in a sense, they can be called on by the Gaming Commission directly, just like a letter of credit. The distinction is that a surety bond, like an insurance policy, the surety will be looking to protect itself. And so in a bankruptcy, the incentive for the surety to fight back on whether the conditions of the surety issues have been met are kind of raised. And so this is an active concern on for sureties. If you go, if you just go online and sort of look for this world, you'll see there's a lot written for insurers on how to protect themselves from bankrupt bond, issuing bonds on behalf of bankrupt entities or having to pay on bonds for bankrupt entities. So that's really the sort of, I would say it's probably a 1A, 1B between letter of credit and surety bond. Cash is the one that worried bankruptcy counsel, and we consulted with them the most about the ability to pay in those instances. But that's where some of the different instruments do have that variety.
Definitely not as protected, I hear you saying, but maybe more protected than where we are today.
A bond would be more protective than cash because again, it's if it's issued by surety company A, that's who actually is holding it. They're not the debtor, so it's not an automatic stay on that. However, it's sort of a slightly higher bar to convince them to let go of the money than it would be with a bankrupt letter of credit, where they have less defenses to say, no, you can't have the money right now.
I have a quick academic question for you. Would a bankruptcy judge, if looking across the country, how much value and weight would they put on the Massachusetts Gaming Commission having this money set aside versus just taking that pot of money and spending it on any matter of liabilities they want to spend it on?
Right. So with the cash reserves or trust accounts or anything like that, the feedback we got from bankruptcy counsel at Tom Bean at Veral Data on this is very little. Right. The federal law is very clear that state regulations don't trump the bankruptcy code. And if you're talking about a national company with lots of creditors, this is not going to be their concern. The letter of credit, that sort of advantage there is it shouldn't have anything to do with the bankruptcy, right? It's a letter of credit issued for the benefit of the Gaming Commission by a bank, and assuming the bank itself has the money still, right? They're not bankrupt in some way or insolvent. They're paying you the money being held for you, as opposed to on behalf of their former customer, now bankrupt customer. But that's why they suggested the letter of credit approach as the safest in bankruptcy, because a judge would probably, if nothing else, at least subject it to the stay, not the automatic stay, but to a stay pending the bankruptcy proceedings, and whether they use the money or at least make everyone wait for the money. They're unlike a bankruptcy judge is unlikely to say, go ahead and pay these folks in Massachusetts first before anybody else.
So thank you for that. And commissioners, I'm just going to let you know where I am on this. I'm much like Commissioner Hill, I think, and Commissioner Broder. I don't want to add a liability to the operators and become, go out of line with what's going on in other jurisdictions if there's a potential that the patron's not going to be favored anyways. I mean, the odds are higher they will, they maybe not. So, I want to be as fair in making this balance as possible. So that's just where I am. So what do we want to do, commissioners, with this one?
Mr. Chairman, for discussion purposes, I want to keep it with where it is, with the exception of adding a definition that would be clearer for our consumers. That's where I'm at. But I do want to address what the Attorney General did say in her letter.
Absolutely. Commissioner Broder, I see your mic's off.
Yeah, I mean, I'm in the same spot as Mr. Hill, and I can't help but thinking, we're I don't want to open up a whole new front in this, but as we think about who who we want to protect in what seems like a fairly unlikely event of a bankruptcy. Certainly the consumers of the Commonwealth, but I'm also thinking about the employees, the small business vendors in particular, that would also be, significantly impacted by this kind of disruption. I don't know if we need to think about that some more. I do think we should keep this, particularly along the definition, she'll keep this moving, but I'm, like Commissioner Hill, comfortable with not taking any action at this time.
Except for the clarification for okay. That's where I am too. Commissioner Skinner, I see your mic's off.
Yeah, pretty much most of the above. Again, I'm gonna say where I differ in sentiment is that I do think that the letter of credit requirement is already out there. It's out there for liabilities. Again, I don't know how the thinking is going right now in terms of defining liabilities, but right now my understanding is that that includes wagers pending and wagers that have been decided but have not been paid out. Right. I would like to see again the regulation shift to place greater protection on what is in the patron account, as opposed to money that the wagering person, the patron already stands to lose, already pretty much agreed to part with, right? In the event that their wager is a losing wager. So I think that is where I'd feel comfortable. I know that's where I'd feel comfortable. I don't see that as imposing any additional requirements. I just see that as flipping them. Because again, the letter of credit requirement is already out there. I hear the Attorney General's office in that we need to clarify what liabilities are, but I also hear the Attorney General's office in their position that the monies in the sports wagering account should be protected.
Commissioner Skinner, and I will say again, we do have a level of protection today, right, for the consumers and for the public. Commissioner O'Brien.
Yeah, I mean, what I would like to see is the definition that hopefully satisfies, the five of us, and in particular, the issue raised by the AG. And I think if Justin puts pen to paper with Mina and describes what we're talking about, I think we all have the sentiment that at bare minimum, money sitting in that account need to be protected. Just like, I sort of conceptualize that anything that would have been handed over to abandoned property after 3 years of no use, to me, absolutely should be protected and go back to the consumer. So we need to do what we need to do to make that happen. So if the avenue to do that is potentially defining liability and amending the reg, that's my preference.
Yeah, can I just jump in? I'm sorry, Commissioner O'Brien. I don't know that we're all on the same page here.
To me, it would jump off the conversation, right? Because I feel like we're close with a couple things. So if it were defined, I think we could bring this in for a landing on whether we're going to change anything or whether we're going to do that by whether the definition solves it or whether there's something further to talk about.
Yeah, and I made that same statement. I'm not sure what it is we're contemplating with respect to amending the term liabilities. I think that needs to be fleshed out so that we can all understand what exactly we're proposing.
I think Justin's jumping in on that.
I can shed some light on that. And so my understanding from reading the AG's letter was that they're looking for, since we don't define sports wagering liability, and they suggest some structure to that definition, which is well taken. My sense of what that definition would be would essentially reflect the active wagers that have not settled, and it would be something like, I haven't drafted it yet, but that would be fairly easy to draft. So that would, even with that definition, however, we're still going to have the letter of credit issue where the letters of credit. Oh, Mina's raising his hand.
When you finish up.
Yeah, so that would still, you'd still have the decision to make about, because the reg as written currently, the letter of credit is covering sports wagering liabilities, not account balances. So even if we define sports wagering liabilities, the definition would still reflect the bets that haven't settled. So you're not going to I don't think we solve the issue here. I think we would clarify what we mean by sports wagering liabilities, but we're still going to ultimately have a regulation that has a letter of credit covering active liabilities, not account balances. I mean, it's not in his head. So I don't.
Yeah.
You have anything to add, Mina?
Yes, I just want to, Justin, I think you're not giving yourself enough credit. The revised regs, I mean, they can easily be carried into the definitions, but the red line regs is around page 61 of your packet. Changing the word in 238.12.1 from including the amounts accepted, et cetera, to consisting was the effort to define what sports wagering liability is. We can certainly add that to the definition section since we were only looking at 238.12. That's where we left it for now. But sports wagering liability, the idea was to define it as those two things. It wouldn't be the sports wagering accounts, which do have a separate definition because, among other things, to Commissioner O'Brien's point, there's other portions of the regs that cover what happens if they're abandoned and sort of go through the abandoned property process on the state level. So I think we can make that clearer in the definitions in 202, or the commission could. But to Justin's point, the key issue then is once you do define those two things and you're clear on the definitions, which instruments are you requiring to back up which ones? That's really the operative issue.
Hey, you mean we give Justin a lot of credit.
I haven't had a chance to
No
look
pun
over.
intended. No pun intended. Commissioner O'Brien, I see your mic's off again.
No, what Mina said just makes a lot of sense to me. I just haven't muted.
So what do we want to do? Do we want to maybe potentially see a definition? Maybe kick this back to a conversation to the AG and then come back for a landing?
That would be my preference.
Mine as well.
Because I think we're hovering on a consensus, but I don't think we're there yet. And I do think I want to make sure I'm with Commissioner Skinner and that I want to maximize the protections for the monies that I conceptualize it really belongs to the consumer and how best to do that.
Yeah, for me, this doesn't hinge on the definition of a liability because as I understand it, it does not include and it is not intended to include the money sitting in the patron account. So it doesn't, I agree just for efficiency and we should be reviewing what the proposed definition of a liability is, but unless it includes, and I don't think it will, but unless it includes the money sitting in the account, I don't think it goes far enough for me.
So here's the other thing that I was thinking about, which was, do we need another definition in terms of, consumer account act? Like, is there some other way that we define that money, Mina, that you're talking about that would be, subject to abandoned property and 3 years of inactivity? Like, is there a way to capture it that way?
I believe that's already defined.
Okay.
As I think the term sports wagering account is defined. And what I was getting at is sports wagering liability wasn't. It's described in what could easily turn into a definition in the revised, in the red line on page 61 of the packet. But the definition of an account already exists. It was a definition of a liability. But Commissioner Skinner is correct. The current reg does not require a letter of credit or other, non-cash instrument backing up sports wagering accounts. One of the three options would require that, or maybe more than one of the three options would require that. But that's what it would do.
Right. Okay. So thank you for that clarification. So I think Commissioner Skinner and I are kind of in alignment on that. I'm looking for the same result that she is on that.
Yeah, the biggest thing, I'm not saying I am or I'm not. What I'm saying is I don't want to create a big pot of money that costs a little more to make here in Massachusetts on the operators and then it go to a different jurisdiction somewhere in a bankruptcy if it ever happens. By the way, I'll remind everyone, this is really, really an academic exercise we're doing because the hope here is that no one will go bankrupt in the Commonwealth, none of the businesses. But I'm not opposed, Commissioner Skinner, Commissioner O'Brien, to the idea. Commissioner Broder had his mic off too.
My mistake, sir.
Oh, my mistake. Commissioner Skinner.
Yeah, I think I think just revising the regulation to require the letter of credit protect the accounts as opposed to liabilities, I don't think that is imposing an additional burden on the operators, because again, we're shifting the priority here. They're already required to have a letter of credit for the liabilities. My proposal, and I think Commissioner O'Brien shares this direction, is that instead of the liabilities, the letter of credit protect the money that's sitting in patron accounts. I just want to make sure that that is clear, because there's a concern among us all, I think, that we're imposing some additional requirements. And I don't quite see it that way. It's still the same requirement. It is just refocusing the priority on the different aspect of the funds.
So Commissioner Skinner, if that's the case, I'm very likely to get there. I have a feeling that this will be an additional burden on the licensees. I'm sure somebody could confirm or not confirm that. Whether or not the burden's worth the risk, or whether it's worth the burden or not, is a different question, right? But and I noticed Derek had his hand up. I know Commissioner O'Brien has something to say, but then I want to go to Derek too after.
So just this is more for Justin's edification. I'm trying to remember if you were here for this, but one of the other thoughts that we had to mitigate risk outside this reg was whether it be sort of internal controls or something on the operators, notification reminding consumers that they can withdraw their monies. You know, we had this question of like, I know might be apathy, there might be, frequent flyers who leave a substantial amount of monies in these accounts, but sometimes people forget about them. And so whether there's any other, push out that we can encourage the operators to do, because if the people take most of the money out of the account, then the risk obviously diminishes that something's going to happen to it.
Yeah, one thing we may be able to do to sort of provide some more context to this conversation is to speak to our operators about what is the relative amount of letter of credits that's currently required to cover liabilities versus account balances. And it may turn out that account balances is a lesser burden on the operators than the liabilities, in which case maybe there's more incentive then to flip the reg, as Commissioner Skinner was suggesting, to cover account balances, because it's actually a lesser burden on our operators while maintaining confidence in consumer protections.
And if that's the case, Justin, Commissioner Skinner's got me right with it. Commissioner Skinner?
I like that. I was just gonna maybe propose that we do that by way of voting on the language to this regulation and putting it out for public comment. So giving preliminary approval to language consistent with this discussion, and allow feedback through that public comment process, as opposed to yet again reaching out to operators, which I understand is very important. But I think we've done that a couple of times. We have waivers that are out there. So I think we've heard a lot from our operators. Putting this out for public comment through a more formal process, I think it just saves us some time in the long run.
Thank you. Derek, you have been extremely patient.
Well, it's my pleasure. This is always a fun conversation. I just want to avoid us running into more problems, because if you look at, I think it's paragraph 3, and specifically A of this regulation, I don't, especially with Mina's information that he just gave us about, surety bonds and letter of credits really being the only thing that ensures that the patrons' funds won't be available to any creditors. I don't see how any of the operators meet these definitions. So it does take a bigger redraft if we're looking to just protect either the liability or the sports wagering accounts, because 3A said that there has to be a system of internal controls to ensure that the funds in a segregated account, so those would be the players' accounts, right? The money that you're setting aside, the reserve or those funds, do not belong to the sports wagering operator and are not available to creditors other than the patron whose funds are being held, right? And that's the whole thing we're trying to avoid here. So I don't want to draft something or vote on something today that would kind of have contradictory results.
Mr. Chair, I respect that comment. I just want to be clear about what the different provisions do. And I wonder if maybe going back to the language that's in front of you might help with that, because I think that I want to make sure that there isn't a misunderstanding or some purported admission here. A segregated account.
If you look at 2A above, Mina.
No, I understand, Derek. Yes, 2A says in a segregated account managed in the course of 248. So the bankruptcy court would not automatically say that a segregated account is part of the bankruptcy estate and therefore cannot be spent. A segregated account is an open question. That was the issue, right? So the segregated account has a shot at being protected in bankruptcy, but it's not as secure as a letter of credit, to Derek's point. I think the distinction, though, is so with 3, they still need to do those steps with the segregated accounts that they have. That's the actual money from the patron, not the backup. I mean, I just want to be clear about that. That's protecting the money that came in. The dollar that a patron puts in is actually in a separate account, is not commingled, isn't being used for operations. That's what 3 does. It's also what 248 does. And I also, just to clarify from before, sports wagering account is defined I double checked in 202. What I had forgotten is that it's actually defined in the Act. It's in Section 3 of the Sports Wagering Act in 23N. So that's that one set. What is important, and what we had sort of the different provisions that you have in front of you have to do with what backs up that account, the sort of second dollar put in by the operator. Is that second dollar being done through cash reserves that Derek and his team have some insight into? That money is very likely to end up in bankruptcy. It's that second dollar protecting the first dollar. We're not talking about the first dollar, which is in the segregated account, which may or may not be paid out. So that's just the point. And the comments you got back from the operators were a little bit, different folks had different interests. I think some of the larger companies said, we certainly have enough cash, you should make us put up more. Others said, yeah, letter of credit is fine. And others asked, could we do a surety instead? So that's where sort of you have on the comments so far. But you do have the options there.
I'd like to bring this in for a landing. Thank you, Mina, and thank you, Derek. Commissioners, at least as of today with our pretty lengthy agenda, if we, Commissioner Skinner had said we may, but I'm probably not on the let's just vote for something and see what the comments are line, Commissioner Skinner. Not that I understand your logic and moving the issue forward. But how do we want to deal with this, commissioners? Back to the drawing board.
Mr. Chairman, I had hoped that my original request would be that we keep things the way they are and that we would have a definition come back to us at some point in the future. And we've had a couple of other requests of things to come back also to be seen. So that would be my hope at this point, is leave things as is and then come back to us with definitions and other concerns that were just articulated, bring it back to us in the future.
Thank you.
Ditto for me, Mr. Chairman.
Thank you, Commissioner Broder. Anything else, commissioners? I think I'll join Commissioner Hill and Commissioner Broder for the record, so that way, let's see what this looks like. Commissioner O'Brien, are we good? Commissioner Skinner? Noting your objection, Commissioner Skinner, are you good?
So have we put the idea of protecting, having that additional protection on those funds in the accounts to bed? Is that off the table? Are we not considering that at all at this point? Okay.
It's to see some, I think it's to see some additional language.
Okay. Yep. Then I'm on board.
They heard our concerns today, and I want a definition. You would like some further information on other things, and they're going to come back to us with what they've heard today.
Right. And I think what would be helpful when it does come back, and this is for Mina and Justin, is an overview for us of the varying places for the definition, right? So that we can make sure we're not missing anything, and then see whether or not the language addresses, in particular, where Commissioner Skinner and I have talked about, which is the money's actually sitting in the accounts. Like, what's the level of protection on that? And see any proposed changes, having a conversation on that.
All right. Mina and Justin are both giving us really sad looks. It's okay, guys. We like to think around here.
Mr. Chair, and I know it's been a while since I've spoken to all these, so I don't want to overstep here with Justin or anybody else. We certainly can do that. My only suggestion is you may want to do that sooner rather than later, because I think a lot of this isn't here, so I think we can repackage that up. But I just don't want everyone to forget the conversation, because this is a complicated topic and it's easy to lose track of.
Well, it sounds like some of the options can already drop off. What I'm looking at is we've already knocked some of these options off the table, which will make it easier for us to look at if we only have one or two options to go with, or maybe two or three. But it sounds like we've narrowed it at least today. And thank you always for giving your insight, Nina and Justin and Derek. We appreciate it. Commissioners, we do have couple of scheduling things. One is that number 9 is going to have to be moved up to accommodate our outside counsel. But before that, I believe sports wagering had an issue that they also wanted to go ahead and get out of the way. So with that, I am going to go
Mr. Chairman?
Yes, Commissioner Hill.
5-minute break if we could, please.
Absolutely. Thank you. Okay, Connor, I think we're gonna take this down and see who's on. Carrie, before we reconvene, do we have time to do your matter out of order? With Andrew?
Which one?
Andrew had a request to move one of the operators forward.
Andrew?
Yeah, Carrie, it was the
Oh.
FanDuel house rules. FanDuel has a time conflict this afternoon. I didn't want to lose their presence today.
So that's all my question is are we good to do that before we move to our 11:30?
I'm sorry, I'm not understanding. Do you want to do that next, you mean? That one first, or?
That's all I'm at. This is not a trick question. I was
Well,
told
I don't know what you mean by our
I was
11:30.
told FanDuel needs to leave soon. I was going to take FanDuel out of order. And then I also have another matter that needs to move at 11:30.
Oh, I see.
And so I'm trying to see, do I have the time or do I not have the time? That's it.
Gotcha. Andrew, what's FanDuel's, when's their availability until?
Just sorry, real quick, commissioners. That is no longer a conflict, so I'm fine to stay. And apologies, I spoke up there.
All right.
You will regret saying that, sir.
But then, commissioners, if that's no longer the case, I think we're okay to move with your 11:30 Jordan as planned, and we can take everything in order with sports wagering, if that's okay with Chris, if you no longer have that conflict.
Sure, yeah, that's totally fine. Apologies there, everyone.
All right. Let's see, I think all the commissioners back. So this is a reconvening of the Massachusetts Gaming Commission with that one scheduling piece taken care of. Good morning still, Commissioner O'Brien.
Good morning.
Good morning, Commissioner Hill.
Good morning.
Good morning, Commissioner Skinner.
Morning.
Good morning, Commissioner Brogan.
Hello.
All right. Should we move on? So let me ask this. Should we move on to the 11:30, which is we're going to take item number 9, which is an executive session regarding the SEIU Local 888 agreement. Are we good to do that right now? All right. Let me read some language into the record. So we're going to go ahead and take number 9. All right. I do see Mr. Connolly here. That's what I was waiting for, right on cue. So commissioners, if you allow me. Yep.
Chairman, let me make sure that Derek is back into the call.
All right, I see Director Monahan. I see Derek, and then, so we got Derek and we lost Dean. All right, there's ED Serpa. So let me read the language and then we'll all convene in the executive session. If the commission so chooses to go into it. The commission anticipates that it will meet in executive session in accordance with General Law, Chapter 38, Section 21A3, to discuss strategy with respect to collective bargaining of the SEIU Local 888 agreement, as discussion at an open meeting may have a detrimental effect on the bargaining position of the commission. Commissioners, would we like to enter an executive session?
So moved.
Thank you.
Second.
Thank you. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
And Commissioner Brogan.
Yes.
And I vote yes. So we will enter into executive session, and for the public's notification, we will re-enter into the public meeting to finish our agenda for today. I think we will be moved over.
Just give us
Yes,
1 minute.
I'm opening it now.
Thank you. I think we can take the screen down, Connor. Got a second? All right, I see all the commissioners are back. So this is a reconvening of the Massachusetts Gaming Commission. We just finished an executive session, item number 9 on our agenda, and we're going to re-enter the public session. Since we're doing this virtually, we'll do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon.
Good afternoon, Commissioner Hill.
Good afternoon.
Good afternoon, Commissioner Skinner.
Good afternoon.
Good afternoon, Commissioner Broder.
Good afternoon.
All right, so we took number 9 out of order, so we're going to go back to where we left off, which was item number 5. And for that, I'm going to kick it over to the Chief of Sports Wagering Division, Carrie Teresi. Good afternoon.
Thank you. Good afternoon, Chair and Commissioners. So I have 2 waiver requests for you today. The first relates to 205 CMR 238-12, which you just discussed this morning with the legal department. There's currently a waiver from that section of the regulation in effect until March 1st. You implemented that waiver in October, sort of with the expectation that you'd review the reg and possibly make any changes. I think given the discussion this morning, it makes sense to extend that waiver probably until I would recommend June 1st, assuming that the legal department might come back in February. If you are to vote on a reg, any changes in February would take 3 months, about 3 months to promulgate those changes. So that would bring us to about mid-May. So if you're comfortable with that, I would recommend extending that waiver from 238-12 until June 1st.
Commissioners, any questions about Carrie? I see Commissioner Skinner. Your mic's off.
No questions. I'm ready to move if my fellow commissioners are.
Commissioners, I'm good. I'm getting thumbs up across the board, Commissioner Skinner.
Okay. I move that in accordance with 205 CMR 202.032, the commission extend the existing waiver to all licensed sports wagering operators from the requirements outlined in 205 CMR 238.12 until June 1st, 2025, as granting the extension to the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of General Laws, Chapter 23N.
Second.
Thank you, Commissioner Broder. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Aye.
And I vote yes. 5-0. Okay, we're sticking with you and your team, Chief Teresi.
Great, thank you. So the second one is that we are seeking the Commission's approval of BetMGM's request for a temporary waiver from 205 CMR 255.021B through January 31st. So just for background on this, 255.021B requires sports wagering operators to provide patrons with the option of setting certain limitations on their wagering, including setting a daily, weekly, or monthly limit on how much they can wager. Last year, the Sports Wagering Division identified that BetMGM was out of compliance with this provision, as the limits that they offered related to total loss amounts, but not total wager amounts. So in July of 2024, BetMGM submitted a waiver request from this provision through the end of 2024 so that they could build out the necessary technology. And the Sports Wagering Division approved that waiver request. 255.06 authorizes the Sports Wagering and Responsible Gaming Divisions to approve an operator's use of additional or different limitations than those identified in 255.01, but it doesn't authorize the divisions to approve sort of general waivers. So I think at the time of BetMGM's initial waiver request, it seems there was just a misunderstanding as to the extent of authority granted by that section. And the initial request last summer should have come to the Commission for approval. In December, BetMGM reached out seeking a 1-month extension on that waiver through the end of January so they can just complete some testing. So now that we're aware, of this error from last summer, we just wanted to bring this request to the commission to make sure that we're in compliance with our own regulatory requirements and that the waiver is approved by the commission.
Thank you, Carrie, and I do want to thank you for reviewing waivers that were granted within the sports wagering division that have been deemed to should have come up to the commission, and we appreciate you doing that. Commissioners, do we have any questions for Carrie? I don't either. I think that we will need a motion on this one.
Mr. Chairman,
Commissioner Hill.
I move that in accordance with 205 CMR 202.032, the commission issue a waiver to BetMGM from the requirements outlined in 205 CMR 255.02 1B until January 31st, 2025, as granting the waiver meets the requirements specified in 205 CMR 102.034 and is consistent with the purpose of GL Chapter 23N.
Commissioner Hill, could I just ask for one amendment for it to be through January 31st and rather than until January 31st?
I would accept that friendly amendment.
I'll second.
Chair, you're muted.
Sorry about that. I said second with the amendment, correct, Commissioner O'Brien?
Yep.
All right. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes for 5-0. All right. Thank you, Rich, for being here too for that.
Thank you very much. Next, we have 2 sets of House rules, and for those, I will turn it over to Compliance and Operations Manager Stefan.
Good afternoon, Commissioners. Yep, just 2 House rules updates from you today. The first, beginning on page 73 of your packet, is a revision requested by FanDuel Sportsbook. You can see the summary of changes in the memo. However, scrolling down to the red line on page 75 begins with a change to their baseball house rules. The changes here include the addition of new markets, such as a player to hit a home run on their first plate appearance, spring training games and how they're settled, as well as a change to how certain wages are handled if a player does not record a relevant plate appearance. Moving down to basketball on the next page, a couple changes to these markets include, excuse me, last point market, where this is now inclusive of overtime. New markets also include team to go on a specific run, as well as how many lead changes could happen during the game. And FanDuel has provided clarification for those markets as well. For cricket, which I am certainly no expert, took some time to review on our end. The key changes here primarily focus on clarifying settlement rules for various cricket betting markets, especially scenarios impacted by external factors such as weather or player availability. From our review, these revisions appear to aim to ensure consistency with official cricket rules and competition outcomes, provide transparency for bettors, especially in cases like ties or those external factors I mentioned, and to reduce any ambiguity in settlement processes, which ultimately benefits both the customers and FanDuel. We have no issues with the proposed rule changes for cricket. However, FanDuel is on the meeting to help answer any questions after we wrap up. Moving on to soccer, FanDuel has made changes to postponed and rescheduled matches. What this updated language is stating is if a match is postponed and rescheduled to take place within 3 days of the original kickoff date, then all bets on that match will remain valid. However, if confirmation of the rescheduled start time is not received within 3 hours of the original kickoff, single bets will be void and multi-leg wagers will be settled based on the remaining selections. Matches that have their kickoff time altered prior to the original start time will not be considered postponed. And for matches rescheduled beyond 3 days, all undetermined bets will be void, regardless of whether confirmation of the new start time is received within that 3 hours. They've also made a similar change to abandoned matches, stating if a match is abandoned after starting the event, bets on decided outcomes will stand while others are void. Bets remain valid if they restart. If an event restart within 3 days and is announced within 3 hours, otherwise undetermined bets are void. And from our review, these changes provide much more clarity regarding the settlement of these very specific scenarios, ultimately helping the consumer better understand how their wagers may settle if these circumstances occur. And then lastly, for tennis, there's a slight revision to the settlement. However, the example that has been given is much clearer to the consumer than what is currently stated. And for the aces, double faults market, this is more of a condensed settlement, stating these markets will be settled on the basis of official scoring providers or official tournament websites. And as I mentioned, we do have FanDuel Trading Compliance Manager Chris Black on the meeting again to help answer any questions from their side. However, after a very thorough review, we are comfortable with the requested revisions and would recommend the approval of FanDuel's house rules today. Chair.
Thank you, Andrew, and thank you, Chris, for sticking around with us.
Sure.
Questions, commissioners?
Mr. Chairman, I don't actually have a question about the house rules, but I'm curious, Chris, how did TGL go with the opening the other night?
You know, I don't know if anyone watched it. I tuned into a couple of holes over my morning coffee the other day. It was pretty interesting, honestly. I think you have to be kind of a hardcore golf fan maybe to stick around for 2 hours. But yeah, early returns probably did a little bit better than we expected.
Very nice.
So it'll be interesting to see with Tiger Woods going next week, kind of how that effect bumps those numbers.
Excellent. Thank you for that. And thank you, Mr. Chairman, for allowing me to ask the question. I am ready to move.
Commissioners, do we have any questions before Commissioner Hill moves? I'm seeing none. Commissioner Hill.
I move that the commission approve the updates to FanDuel's house rules as included in the commissioner's packet and discussed here today.
Thank you.
Second.
Thank you. That went to Commissioner Skinner. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, 5-0.
Great. Thanks, commissioners.
Thanks, Chris.
Thank you, Chris.
Next item, beginning on page 87 of your packet, is a house rules change request to BetMGM. You may recall we presented a very similar change to their house rules during the November 21 public meeting just a couple of months ago. That change as presented was to more closely align with GLI 33 event wagering systems, which we have also adopted in 205 CMR 24301. Today's change, as we continue to work with BetMGM, now fully aligns with that standard. The change itself now sets the platform by default to require the user to acknowledge all odds changes, and the user can also make a change to that setting within their player account. An odds change in this context could be when you are placing an in-game wager and something happens during the game that affects the odds, and the odds change before you can actually place that wager. You would have to acknowledge that change regardless if it is more or less favorable. We do have a representative from BetMGM, Trading Compliance Analyst Zach Kraus, on the meeting again to help answer any questions from their side. However, the Sports Wagering Division had requested this change from BetMGM. We are comfortable with the updated language, and we would recommend the approval of this change as it does now fully align with the standard. Chair.
Thank you, Andrew. Commissioners, with the fact that Sports Wagering requested it, do we have any questions? Do we have a motion?
Mr. Chairman, I move that the commission approve the updates to BetMGM's house rules as included in the commissioner's packet and discussed here today.
Second.
Thank you, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yes.
And I vote yes, that's 5-0. Thank you, Zach, for being on today.
Thanks, Zach. Thank you, commissioners.
And thank you, Andrew, Carrie. We appreciate it all as always.
Thank you very much.
With that, commissioners, we're going to turn it over to item number 6, which was something that's set on our agenda setting meeting for a while, and Christian pulled it off. So we're going to kick it over to Christian Tavares for that. Good afternoon.
Good afternoon. Good afternoon, commissioners. As you know, a sports wagering operator is required to ensure that its platform is secured and its security processes are up to date within 90 days of commencing operation in Massachusetts. Bally's commenced operation on July 2nd, 2024, and submitted their compliance information to us on September 30th, 2024. And the agency has since completed its review of the materials. Today, I can report that following our review, in accordance with Regulation 205 CMR 243.011X5, no immediate remediation was required, as none of the findings were classified as high severity. Based on this, we conclude that Bally's is in compliance with the regulation. No vote is necessary on this topic. Today's report is meant only as an update to the commissioners. Are there any questions?
Glad to hear this, given our votes earlier today. Got some nods on that one. Commissioner Skinner, your mic's off.
Christian, could you confirm that your division will continue? I understand that there are no high-risk findings, but could you confirm that your division will continue to follow this operator to ensure that any medium or low risk items are addressed?
Yes, we can follow up with them to ensure that they remediate any any low or medium item that was found.
Mm-hmm.
Yes.
All right, and just to thank you for providing the actual documents for us to take a glance at. That was appreciated.
You're welcome.
Anything else, commissioners? Christian, we appreciate that.
You're welcome.
All right. With that, we are going to turn it over to we're going to move to item number 7. And we're going to turn it over to Director Mark Van der Linden.
Thank you, Chair Maynard. Good afternoon, Commissioners. I have a few items for you today. First, a discussion of the responsible gaming framework, as well as the discussion and update from the AI work group. So first, the responsible gaming framework. So before even the first casino opened in Massachusetts, the Gaming Commission adopted a responsible gaming framework. So it's an important piece of work because it provided a set of expectations and an approach through which licensees could ensure that their general practices, responsible gaming practices, were consistent with the Commission's expectations that gaming be conducted in a manner to minimize harm. We had a couple really important pieces of programs that came from this. Play My Way is a perfect example. It was anticipated in that first framework and it was implemented. Game Sense was in there. Even voluntary self-exclusion and the Commission's unique approach was originally conceived and anticipated in that first framework. The framework was updated in 2018, largely because at that time, we had started to gather a lot of evidence through our research agenda that informed and refined the practices that were described in that framework. And at that time, it led to a couple more pieces of work that came before the Commission. There were 2 white papers, one on responsible gaming considerations for gambling advertising, and the second applying principles of the responsible gaming framework to sports wagering policy and practice. Those were 2022 and 2021 respectively. So last year, building upon those 2 previous versions, Commission staff began to work on a 3rd version of a responsible gaming framework, recognizing that clearly, obviously, a lot has changed in the last couple of years. And in order to be responsive to that, in order to stay relevant and up to date and moving towards the best practices, the 3rd version of a framework was going to be necessary. So what I have for you today is really just an overview of a framework that we continue to work on. It carries forward a lot of the lessons and a lot of the same principles in the first 2 frameworks. But again, I think it's time to update it and think about how technology has become front and center and that there's a changing gambling landscape. So I'm going to just share with you my screen. Can you see that? Okay.
Yes.
So the commission has clearly over the years seen responsible gaming as a shared responsibility. It includes certainly the patron who chooses to engage in gambling, but it also includes the commission. It includes our licensees. It includes a range of different stakeholders, both locally, nationally, and even internationally. However, this differs from a historical perspective of what responsible gaming is, which is generally more focused on the individual. And the problem with that is that it puts a lot of the burden on the individual. And by placing that sole responsibility of gambling on the individual, those who are not able to control their gambling are seen as irresponsible and further stigmatized for their behavior. So that's why you'll see in this version of the framework, we're recommending that we move away from the term responsible gaming framework and move towards what we're calling a player health framework. It doesn't lose the intention or the importance of what responsible gaming is. It's still largely seen as a term that's used widely across the country. But I do think that there are enough changes in ways that we look at this issue that a change from responsible gaming to player health is warranted. So with that, what do we mean by player health? Player health is about prioritizing the well-being of individuals who choose to gamble. It includes promoting healthy behaviors and minimizing gambling-related risks. The goal of this player health framework is exactly the same as it was in the original first version of the framework, which is to create an effective, sustainable, measurable, socially responsible, and accountable approach to gambling in the Commonwealth. So a player health framework is a strategic guide of the Massachusetts Gaming Commission to create a responsible and ethical approach to legalize gambling. The framework provides an approach through which gaming licensees can ensure their practices are consistent with the Commission's expectations that legalized gambling in the Commonwealth will be conducted in a manner to minimize harm. The efforts that are described in the framework are largely funded through the support of the Public Health Trust Fund. There are a couple of core principles, and again, these are largely, they've been refined. We're proposing they're refined, but they're largely the same as what was in the last framework. Principally, that gambling, it's a shared responsibility that we as regulators in the Commonwealth have a critical but still limited role in supporting player health. That there are other agencies, other governmental agencies, science, academics, gambling licensees, and the broader community of sports leagues and advertisers that also have a role in this. Another core principle is that of a precautionary approach, and this has been really important for us all along. Recognizing that this is a rapidly changing industry. Sports wagering has really taken off since 2018. And that we're recognizing that sometimes science takes a long time in order to catch up and begin to define what the best practices are. And that shouldn't necessarily stop us from moving forward. And so therefore, a precautionary approach states that when an activity causes some threat or harm to the public or the environment, general precautionary measures should be taken. That said, we would learn from a variety of other fields and a variety of other industries in order to inform what our practices are moving forward and evaluate those. Play My Way and GameSense are both perfect examples of programs that launched from the Gaming Commission that didn't have a robust body of evidence that would stand behind it, but we launched those based upon the knowledge that we did have, and we evaluated them. And we refined them based on the findings of those evaluations. The third core principle is that of a stepped care approach. And you've probably heard me talk way too much about the continuum of gambling behavior. But you can also look at a stepped care approach towards harm prevention. And it suggests that the riskier the playing behavior, the more focused the intervention needs to be. And that there's a hierarchy of interventions defined by different player groups. And so this really gets at, so when you see somebody when you're talking to somebody anywhere on that gambling continuum, the nature of the conversation, the nature of the information that's being presented, the specificity of that information changes depending on the individual. So the core functions of the MGC are to regulate all forms of legalized gambling that fall under our jurisdiction, to develop and implement a research agenda to increase our knowledge and understanding of gambling-related harm, and to educate the public, policymakers, gaming licensees, and others on the evidence-informed practices to protect our players' health. Each strategy contains a number of related practices that are described in what I'm proposing will be a companion document to this that would provide a lot more very specific tactics and measures that can be taken in order to achieve these goals. And you'll see that this is further described on this slide, that research, education, and regulation are on the outside of the circle, that our goal to promote player health by reducing gambling-related harms is in the center, but there are 7 different strategies that are defined. These are largely the exact same strategies with slightly different, slight changes from the first 2 versions of the framework. But as we move into what the specific tactics are that support these strategies, you'll begin to see that it will lean heavily on changes within the gambling landscape and the technology that is available to us. Again, that is a work in progress. So the last slide is really just a brief explanation of each of these strategies, and I won't go into great detail of those today, but they will be guiding what the tactics are. So, Chair and Commissioners, I guess overall, I highly recommend that the Commission continue to engage in a more detailed 3rd version of the framework. The division welcomes any information that you have on the document that has been presented, as well as any support and guidance in the companion document that will provide more detail.
Thank you, Mark. So Commissioners, anything we'd like to add to what Mark's presented or any comments? Commissioner Skinner, I see your mic is off.
A couple of comments. Thank you, Mark, for presenting this. I think it's great that we're taking a third now look at the framework. I was doing something different in 2018 when the original framework was adopted, and also in 2021 when the updates were made. I like sort of the shift to rethinking about the term responsible gaming. I'm reminded of the DPH conference that a few of us attended last year, and we got the opportunity to hear from folks from the Ambassador Project. And one of the comments that resonated with me from that session was, right, the underlying assumption in the responsible gaming terminology is that if an individual is that when an individual has an issue, whether they be high risk or lower risk, that the assumption is that they've been irresponsible in that. And I think that DPH, who sort of coordinates, I believe, the Ambassador Project, I think they're doing some great work in this space. And I would like, particularly on the strategy of promoting public health and safety, I hope there's room for us to, as we are engaging stakeholders across the board for all of our strategies, I hope that there is room to engage, in particular, the Department of Public Health, because as you acknowledge in your spreadsheet, your PowerPoint, they do have a very significant role to play. And I think as we are creating new strategies and altering some of the strategies that we already employ, I would like us to take a look at what's already out there that maybe we can adopt and sort of roll into our own framework, right? Where there's overlap in what we do and what other stakeholders are currently doing and have been doing. You mentioned in your spreadsheet having the benefit of sitting with stakeholders as part of Mass Council, the Mass Council's lived experience group. And I think that's going to also be important as we continue to rethink our framework. In other words, I guess what I'm getting at, and I think you've acknowledged this, is, you know, I think our strategies are working. I think there is room to improve. And so I hope that aside from just a shift from, you know, the terminology, I hope that we are really taking this opportunity to rethink strategies associated with this new way of thinking about that terminology.
Thank you. Yeah, I think it can create an opportunity to open up more doors for partnerships to a wider range of stakeholders. I absolutely agree.
Yeah.
Thank you.
Thank you. Commissioners, anything to add? I agree with Commissioner Skinner. You know, in Massachusetts, we don't just pay lip service to player health. We put our money where our mouth is. And Director Van der Linden has been at the forefront of that during his entire tenure here. And every commissioner and executive director from inception to today has put a lot of thought into this. And I think it's what separates us from other jurisdictions even. Great. All right, Director Van der Linden, with that, I think that you have a couple more things that you want to go over.
Sure. The next on the agenda was just a general update about the bet blocking application or bet blocking software. So I have a memo for this. Interestingly, guided by the responsible gaming framework, the commission has adopted a range of different types of programs really intended to equip sports wagering and casino patrons with information and tools to support positive play, to support informed player choice, but also to assist those who are experiencing gambling-related harm. In October, the Gaming Commission approved an allocation of funds to support the procurement of bet blocking software for Massachusetts residents who want to refrain from accessing digital and online gambling applications. Generally, bet blocking software is installed on mobile devices and computers, and it would prohibit users from accessing all betting sites. So bet blocking software provides protection in a variety of different ways. It blocks both legal and illegal sports wagering and iGaming sites. It blocks any related pop-ups and ads from appearing on the user's devices. It can provide an additional layer of protection for underage patrons attempting to access gambling sites. And it can provide an extra layer of protection for those who are already on the statewide voluntary self-exclusion list from accessing illegal sites. So there's one jurisdiction in the US that we are aware that is currently offering this, and that is the Ohio Casino Control Commission. We've spoken a couple of times with them to just get an understanding of how it's being used and what the success is. They seem to largely be using it as that sort of companion to their statewide voluntary self-exclusion list. And they said that roughly on average, about 15% of all individuals who enrolled in that statewide voluntary self-exclusion list have taken advantage of this additional layer of protection. I'm confident that this type of tool can be used in a variety of different ways and promoted through a variety of different avenues, including through our GameSense program, perhaps through the statewide helpline, through community stakeholders and advocates. We've begun the process of drafting an RFR. There are a handful of companies that can provide this type of service. And so the purpose of that RFR would really be to take a look at what they're able to provide and at what cost in order to get the best product possible for the Commonwealth. I expect that we'll have that RFR drafted and released by the end of the month, and that on the timeline after that, within hopefully 2 or 3 months, we would begin. This would be a tool that would be available in Massachusetts.
Exciting news, and I'm happy that our friends down in Ohio will help pilot this. I think it's a great tool. Commissioner Skinner.
Yeah, I think it is exciting. I, for one, am going to be particularly interested in how this software will block the websites of the illegal operators, because I know jurisdictions outside of the US have had some difficulty on some level in blocking those illegal sites. And so it's good to hear that it can be done. I mean, even where we know, I hope, where we know that it's sort of, there's a rapid adjustment of the websites or the URLs so that those operators can sort of avoid detection. I just really am interested in seeing how the technology is able to keep up with that. The other question I have is your third bullet talks about an additional protection for underage persons attempting to access gambling sites. Do you have any insight right now as to what what you have in mind there, or what this application can do along those lines?
Well, I think that within what I envision, Commissioner Skinner, is that within a household that where this software would be installed, it would prevent unintended users from accessing it from a computer within the home, whether a personal computer and somebody who's underage, if it's installed on their computer, it would prohibit them from accessing any of the sites. So I think it's just there's a way in which I think it can be utilized that would provide a layer of protection of preventing those underage from accessing gambling sites.
Okay. All right. So yeah, I'm interested in obviously more to come on that, because if we're just talking about computers that are primarily utilized by underage individuals, that's one thing. But there is also this practice of an underage person utilizing a computer that's primarily used by an adult, or a device that's primarily used by an adult. So it'd be interesting to see how that gets reconciled as part of this process.
Commissioner O'Brien.
So yeah, in that vein, just thinking from a public safety perspective too, one of the things we want to keep in mind is our knowledge and experience, whether we want to reach out to like AG and MGAA, because this could be something that's, conditions of probations. If someone's put a minor at risk, somebody has a gambling addiction, has minors in the house, it could be another tool to help minimize access. So just something to keep in mind as we're moving forward with this, but really happy that it's at the stage that it's at.
Thank you, Commissioner. Yes, definitely.
All right. Anything else? Okay. I think you have one more piece of information, Director Van der Linden.
I do. Next up is a discussion, an update of the work that the commission is engaged in around AI. I'm going to share my screen with you again. Again, referencing the framework, and that's not by coincidence, by the way. As the gambling landscape continues to evolve, driven by innovation and technology, so too must our strategies and practices to mitigate gambling-related harm. And this is a direct quote out of the 2018 version 2 of the framework. It's important for the commission to develop and implement strategies to effectively reduce harm in all gambling, MGC regulated gambling formats by utilizing evidence-based approaches that target characteristics and manifestations of risk unique to each format. So this purpose of this presentation is to provide you with an update on work to date that the commission has engaged in, including that of our AI working group. So one of the things that became clear, especially to the AI working group as we were engaging in this, is that not everybody understands the term artificial intelligence the same. And so we developed sort of a working definition of what we mean by this. AI is an umbrella term that encompasses many initiatives that use a computer to perform tasks that would usually require a human to complete. It includes predictive analytics, predictive modeling, behavior analytics, machine learning, and machine intelligence. When we talk about risk identification technology, the term that we're using is it's AI-driven technology to identify and to respond to risky gambling behavior. So this is just a sort of a general diagram illustrating how this would work. So a player risk identification model utilizes machine learning algorithms to classify individuals based on their likelihood of being at risk for problem gambling. These models are trained on behavioral patterns such as increased time spent on site or chasing losses, as well as account activities like account depletion or cancellation of withdrawals. The models look at the propensity of somebody, largely they look at the propensity of somebody that would ultimately end up self-excluding, which is both I think a strength of these types of models, but also a limitation that it has a narrow focus. It identified markers of harm and effective thresholds to ultimately generate a risk score to identify players at risk and provide an intervention at each of those different risk levels. So this is going back a ways, and this is when we first began on this journey. We released an RFI that was designed to gather insights into key considerations that the Gaming Commission should account for in determining its approach to risk identification, response, and technology in online sports and land-based casino environments. We largely reached out to received responses from what are considered off-the-shelf products, and that included BetBuddy by Playtech, Game Scanner by Mindway AI, the stability, player stability eScore by TransUnion. We also, that sustainable interaction by Preventer Suite and Necton did not respond to the RFI, but they had publicly available information that we were able to use and add to some of the body of information that was presented when we released that RFI, findings from that RFI earlier in 2024. So there was also an AI work group that was formed back in February 2024, and you can see from this esteemed group that it represents a pretty diverse swath of the divisions within the Gaming Commission. And a big thanks to Commissioner O'Brien, Grace Robinson, Carrie Teresi, Andrew Steffen, Kevin Gavro, Justin Stimpek, and our former Northeastern University co-op, Diana Shao. So another sort of key piece of information that we gathered was conversations with the New Jersey Division of Gaming Enforcement. They took a bold step and being the first in this country to really try to push this, the use of AI forward. And so operators, before rolling out it's what they consider responsible gaming best practices in 2023, the New Jersey DGE consulted with operators about their methods for identifying player risks. At the time, most operators were not utilizing technologies for that purpose. You can see in a short period of time, this has evolved quite substantially. They developed 10 different triggers five based on account activity and 5 based on player behavior to detect potential problem gambling behaviors. Operators have the flexibility to include additional triggers or adjust the RG best practices at their discretion, but also with approval of the New Jersey DGE. The operators are required to participate in monthly reporting process and allow the DGE to audit their practices and evaluate the effectiveness of the triggers implemented. So when we ultimately went out and spoke with the AI work group, went out and ultimately spoke with each of our operators, we wanted to have a better understanding of what their experience was with the DGE's RG best practices, and I'll cover that here in just a second. Another piece of information that kind of begins to put the puzzle together is the work of the International Gaming Standards Association. Their president, Mark Pace, I've had a couple conversations with him, and they have released a series of AI best practices that are really intended for regulators. So just briefly, each AI algorithm must have a stated and documented goal at the beginning of inception. Each algorithm must be audited both internally and externally by the AI algorithm's application owner at least biannually to check and validate that the application continues to behave as originally documented. Each AI algorithm is allowed to evolve on its own within the context and constraints of, but must ensure that all regulatory or legislative requirements are maintained at all times. Each algorithm must have an objective that guards against bias, against discrimination, and against player harm or other unintended consequences. And if there are unintended consequences, then the algorithm owner has the transparency obligation to notify all affected participants. Again, these were AI best practices put out by the International Gaming Standards Association. This would apply to much broader swath of the use of this type of technology than a limited purpose for responsible gaming. But I think it was an important for the commission to consider. So we also, in the 2024 research agenda was a study on AI. So we sought to engage at least one qualified entity to conduct a study on the current and possible uses of AI in the gambling industry. And we drew the net quite wide on this, focusing on player marketing, player acquisition, responsible gaming, functionality, and player health. And so in September, we awarded this to the UNLV IGI, the principal investigator, Khazra Gararian, is a global expert specializing in the use of AI, machine learning, consumer protection, and payment modernization. So that, we expect a final report of this in sometime this upcoming summer. We also engaged with the Mass Council on Gaming and Health Lived Experience Advisory Panel. And the purpose of this, recognizing that there is a lot of effort and a lot of work that's being done in identifying player risk, but how we respond to that player risk is equally important. And understanding the perspective of this lived experience community, meaning those people that are in recovery from gambling disorders or their families or loved ones. I think considering what they have to say of what would be an effective intervention or what the Gaming Commission should consider as we move forward in the space is really important. So we met with them in November and December. I envision that as we continue to go down this path, that I would love to continue to have discussions with them and utilize their expertise. Diana Shao did a very brief literature review. So you can see that there's a number of predictors that are listed that would predict risky gambling behavior, including number of deposits, number of bets, number of active days of gambling, fluctuating wagers, canceled withdrawals. And the outcome of those, as I said before, one of the strengths of a lot of the research is that it primarily says of all of these individuals, who is enrolling in a self-exclusion program, who is excluding. But we know that not all problem gamblers ultimately end up excluding. And so you may actually end up leaving out a large swath of people who are experiencing some type of gambling related harm who may not be identified. So that there was also then some research that was using a different measure, looking at the PGSI or problem gambling severity index as sort of that marker of harm in building the algorithm, building the tool from that. But as Diana pointed out through the literature review, there was a couple remarkable limitations. One is the lack of thresholds, meaning like at what point we identify these predictors, but then at what point does it become a problem? And there wasn't clear consensus on what those thresholds were for these types of predictors. The other was that there's sort of a growing body on this, but not a lot of it was focused specifically on sports wagering, where it would be primarily the space that the Gaming Commission would be interested in implementing this. So this leads to the meetings that the AI work group had with each of the operators. So in September and October of 24, so a few months ago, we held individual meetings with all of the operators to gain insights on their use of AI risk identification and their interest in working with the Gaming Commission to continue to advance this. So just without going into great detail, there were quite long meetings over a period of time. The question of, do operators tend to use off-the-shelf or in-house developed applications? And it was interesting to see, considering what I had known to date, at least, that most of them were developing in-house models. And actually, I think 6 of the 8 of them were working on in-house models. One of them had an in-house model, but also used an off-the-shelf model, like Mindway, like Necton, one of the companies that we received responses from in that RFI earlier in 2024. We asked them about their experience with the New Jersey DGE. Most of the operators are also in Massachusetts, are also operating in New Jersey. Some of them expressed that they were actually had predictors and efforts that were going above and beyond what the minimum standards of the New Jersey DGE had laid out. And that some operators were advising that we look more towards an outcome-based rather than prescriptive. So theirs is prescriptive, meaning here's 10 different predictors that you need to follow. And based on those predictors, this is what the intervention looks like. Whereas some of the operators we met with said should look more at the outcomes and build backwards from that, which I thought was an interesting an interesting insight and important for the Gaming Commission to consider. In terms of future plans, it was striking to me that how many of our operators were working in this space already. It was equally striking that it was in the early stages of development. And so some hadn't launched their product yet in any of the markets. Some had launched in different jurisdictions, and we're not talking just in the US, but we're talking internationally. Some were considering, even though were working and moving towards this sort of in-house system, they were looking also at opportunities and options for off-the-shelf projects. Okay. There was pretty much universal consensus that data privacy and security was of great concern to them, and so they were cautious. Some have concerns about sharing data with third parties, and that there's a focus on developing AI policies to ensure compliance with they wanted to make sure that they understood what the data security regulations were in order to comply with those. And also, I think, a significant consideration of the commission move forward. So this is a slide that kind of takes us back to February of last year with one slight edit to it, which is highlighted in yellow. But it also kind of highlights that we're kind of doing what we said that we would do in order to try to pull this together. So we did a significant amount of background analysis, including expert consultations, the RFI that I spoke about, and beginning to sort of narrow what the focus of our AI work should consider. Understanding the local context, we met with each of our operators. We met with the lived experience panel from the Mass Council on Gaming and Health. We assembled a work group for the MGC, and we launched a research project on the topic. Third, identify possible options. And so initially, we laid out 3 different possible options, i.e. establish regulatory criteria and outcomes, identify and mandate one solution for all operators, consider asking operators to collaborate on a common solution or criteria. The new one that I wanted to just highlight in a little greater detail is establish minimum standards in an audit process for the use of AI for risk identification in Massachusetts. Ultimately, the commission will need to review possible options and consider how best to move forward. So before I kind of go into this next slide, I do want to say, there's a range of options. We have a research project that is out and in the field right now, and it will absolutely provide some valuable insight for the Gaming Commission to consider how and if we move forward in this space. So there is, I think that's an important consideration. But through the AI work group and through the work to date, there is another option that I think is worth the commission considering, and that is that each sports wagering operator be allowed to develop and implement their own risk identification solution tailored to their specific platform and player base. To ensure that the solutions meet regulatory standards and effectively protect players, the MGC would engage with a third-party independent vendor to conduct periodic audits of the operators' models and practices. They would evaluate the effectiveness, accuracy, and compliance of each of the operators' systems and responsible gaming interventions. The benefits, especially after meeting with each of the operators and understanding a wide range of efforts in the space, that it would provide flexibility to develop a model that best fits their platform and encourages innovation that is already currently underway. I think some of the challenges are that data privacy and security, especially if the Gaming Commission chooses to adopt an audit process to assure consistency and that the interventions that are being deployed are working as effective, as intended. I'm sorry. So just references from the Diana's literature review. That's a lot, I know, and I'm sorry. I think there is a lot to consider. I think there's a lot that is happening in this space, and that as soon as I finish this presentation, something new is probably coming down the pipe. So, but thank you for your attention.
Thank you, Director Van der Linden. Commissioner O'Brien, anything to add? I know that you were on this.
No, so my two biggest takeaways really were what Mark led off with, which is everyone's definition and concept of AI is different, right? So you have to be sort of broad in letting people know what you're interested in. And then the other component of this that we've talked about is not only what do we want to do? Do we want to have requirements? Do we want to have this embedded in internal controls? Do we want an audit function that we do? It's also the interplay with how AI is used on sort of the marketing, advertising, retention end, right? And so you don't want to necessarily, there's going to be a tension if we try to say we're banning or restricting on one reason of use. What does that mean in terms of the RG part of it, right? Like, so there's another layer to this conversation that we've talked about, which is how do they use it for outreach purposes, VIP, that sort of thing? Because that to me is the other part of this question in terms of what, if anything, we want to do in terms of our reg or requirements for internal controls or reporting or auditing. So Mark's right, though. You feel like, you get done with a couple of them and then everyone is doing this, but everyone is doing it very differently. And a lot of them are doing it in-house.
Thank you for that perspective. Commissioner Skinner's mic was off and then Commissioner Broder.
Yeah, just expanding on what Commissioner O'Brien was just saying, I think there's another component too is, it's one thing to identify those risk factors. And I give kudos to the work group because, just tackling, the concept of AI, and I'm trying to understand how we utilize it in this space, I think is a tall task. But you've clearly laid out a path forward with respect to identifying those risk factors. But the elephant in the room for me is what then do we do with that information in terms of applying that to our player health strategies, right? How do we utilize that information in a way that is going to benefit individuals who exhibit those risk factors? I think that's I think the next phase, but it's just as big of a task for us to undertake as a commission than the one that is being undertaken now, in that we're identifying those risk factors. So just something to consider as we move forward. Part of me feels like we do need to have that conversation sooner rather than later, so that it does inform how we want to utilize AI in identifying these risk factors in individuals. So I don't think we can completely rest on separating the two phases. So just something for the work group to consider. I think it needs to be embedded. The phase 2 needs to somehow be embedded in the phase 1.
Thank you. Commissioner Broder.
Sure, real quick. I want to thank you and the working group for all the work that has already gone into this. It's a beast, right? One thing that I'm curious about is in identifying the predictors that we see on the PowerPoint. They're all betting conduct related, if that makes any sense. With some of the information TransUnion or an agency like TransUnion can bring to bear, they can identify potential predictors or risk elements outside of that. Is that something we're contemplating, or the industry is contemplating using as they consider? In my mind, it's certainly a great tool for for identifying customers that leads to significant concerns on the marketing side, but also might create opportunities, recognizing the confidentiality issues, but for an expanded sense of what player health means and how to get it.
Thank you, Commissioner Broder. That is a good point. Right, there is a product, the E-Stability Score by TransUnion, and I would tell you if there were more, but it's just the one that I'm aware of. That would take a look at financial data as one of the variables in determining a player's level of risk. And it's being used in the UK. And in fact, part of our research with UNLV is that they're doing a case study with the UK's financial risk identification practices to determine what the potential implication and recommendations for Massachusetts specifically.
That's excellent. Outstanding.
So I'll add in here that, Mark, I support you working with the operators, which you said you've already started doing. I think that was a good suggestion. I think developing a floor as you move forward, I wouldn't say throw a floor out right away, but you had that listed, caught my eye, and I think that makes sense. As far as the vendor piece goes and the potential for auditing, I don't know what my fellow commissioners think, but I think that, work with the operators first, then start developing what that floor looks like, and then maybe we start talking about auditing and vendors. Kind of a step approach is what I was thinking as you were going through your suggestions. I don't know how everybody else feels, but that would be as one commissioner, my suggestions. Basically, I'm supporting what you want to do and then saying, let's see what happens. See what happens.
Chairman, if I could ask a question. So it sounds like you're recommending that we meet on a semi-regular basis with operators to kind of track their progress in implementation or use of these types of tools to identify player risk. Is that all right?
I'm looking at the faces of my fellow commissioners, but that sounds good to me.
It does. It makes sense to me too. I mean, I was surprised at just what a wide range of efforts are in place now across operators and at different stages of development. And when you think about, we launched that RFI in 2023, same time that New Jersey was preparing to launch their RG best practices. That's just not a lot of time. And of course, there's a lot of movement in order to kind of refine the use of this type of technology to identify player risk. And it probably will continue to evolve. So.
And we would encourage the operators to work with Mark on this. Anything else, commissioners? All right. Director Van der Linden, thank you so much for those updates. And we look forward to the next one. With that, we're going to turn it to item number 8. And we are going to kick it over to the Chief of Investigations and Enforcement Bureau. Director Monahan.
Hello, just making sure everyone is on here. Fantastic. So for the first matter, Deandra is going, Nate Kennedy, our enforcement counsel, is going to provide an overview of the IAB's recommendation of assessment of a civil administrative penalty. So I'll turn it over to Nate.
Thank you. Good afternoon, Chair and Commissioners. Nathaniel Kennedy on behalf of the IEB. Today, the IEB is presenting its recommendation to the Commission to assess a civil administrative penalty in the amount of $10,000 upon Penn Sports Interactive for a non-compliance event occurring between November 6th, 2023 and November 9th, 2023. The regulations implicated in the violation are 205 CMR 247011, 205 CMR 247012I, and the Massachusetts Gaming Commission Sports Wagering Catalog. The IUB had originally briefed the commission on this non-compliance event back in June of 2024. And on that date, the commission had decided to assign this matter to the IUB pursuant to 205 CMR 232011A. Just to refresh the commission's memory, the facts of this incident involved 27 college basketball games where one team did not belong to the NCAA Division I. The games took place between those dates, November 6, 2023 and November 9th, 2023, for a total of 249 wagers, or a total handle of $12,075. The participants who placed winning wagers were allowed to keep their winnings, while losing wagers received a cash credit in the amount of their stake. On December 12th, the IAB submitted its recommendation to the commission, which I recirculated on Tuesday, January 7th, for ease of access. As outlined in the recommendation, the IAB had investigated this matter. We reviewed the remedial measures that PSI took and checked to see if there were any other concerns for the causes of this incident. And during the IAB's review, no additional information was uncovered that would change the nature of the noncompliance as originally presented to the commission. PSI was very responsive and communicative through the process and indicated they would accept the IAB's recommendation. And based upon the IAB's review, communications with the operator, and guidance from the commission, the IAB is recommending the $10,000 civil administrative penalty upon PSI. At this stage, the commission has two options. You can adopt the IAB's recommendation as the commission's final decision, or you can reject the IAB's recommendation and issue a notice of intent to adopt a separate recommendation following an adjudicatory hearing. Prior to making any decision, I'm available for any questions or comments.
Commissioner Skinner, I see your mic's off.
Yeah, thank you, Nate. Have the monthly audits that PSI implemented in response to this incident continued since December 2023?
I believe so. I don't know exactly what their procedure is at this point, but I spoke to the Chris Soriano most recently, and he said that they have been checking to make sure that this does not happen again. So it has not been flagged for them since this incident.
Okay. I'm inclined to accept the recommendation that IAB has put forward. I think I would also be remiss if I didn't acknowledge PSI's response to the non-compliance incident. I think they did all the right things here. And I think in a lot of ways, their response serves as sort of a model and what I would like to see with, other non-compliance incidents. So just putting that out there. The non-compliance did happen. And so I'm not going to go against what the recommendation of IAB is, given that we've already set the tone for that. But thank you.
Thank you.
Commissioner O'Brien.
So I have some questions for you in terms of the, these were basically illegal bets. And yet it looks like they were allowed to go through and be resolved in a way that I'm not really comfortable with. They should have all been voided, and whether they wanted to then give monies to the people who won the money to somehow make them whole, et cetera, is different than allowing people who won to keep the money and then giving only the stakes back to the people who lost. I mean, according to our statute, these all should have been voided, and the monies, winnings, everything should have been fixed. Now, if they wanted to let them keep as a goodwill gesture and a business gesture and a customer satisfaction gesture to the people who won some sort of bonus bets, cash, etc., I don't have a problem with that. But I'm troubled by the fact that these bets were allowed, that they weren't voided, which in my view, they should be. Win or loss.
Understood. And I can certainly communicate that to PSI. We did check, particularly with the losing bets, to make sure that they had followed the regulation that it was returned in cash to the users. But I take your point for the winning bets as well.
Right. I mean, they're just there's not really a lot of discretion. I mean, illegal bets are supposed to be avoided. So what I would ask is that there be, I don't have an issue with the substantive recommendation in terms of the civil penalty, but I do take issue with that part of the resolution. And I would ask that there be, I don't know, Caitlin, Kathleen, will you tell me the procedural part of it? But that would be the only issue that I have.
We can talk with Carrie at the sports wagering department about potentially sending a message to all the operators, because I think my guess would be that while it wasn't, technically voided in the system, I guess maybe I could see some procedural issues with it, right? If you void and you, I guess how we don't need to get into it right now. I could see some procedural challenges, but we can work with Carrie's group on notification.
And it's something we need to figure out. I mean, there might be different tax implications versus it's a win versus it's some sort of bonus or, whatever, but they need to be treated as voided bets regardless. And whether they, again, come up with other ways to make customers less than dissatisfied because of their error, that's something else to discuss, but.
So can I ask a question, Commissioner O'Brien, quickly, Commissioner Skinner, if you don't mind? So you're saying that if I'm going to do easy math. If I put a $1 bet in to win $10 and I'm the patron and I get back $10, you would say that $1 should have been voided first, and then that $10 back to me is not part of that void process.
No.
The
The entire thing should be back. It never should have happened. So you should go back to be making the person whole before the bet.
Yep.
And then if there's going to be efforts to make somebody whole, I also think that's something that needs to be discussed with IEB, because to be blunt, I don't want there to be a workaround of, we voided it, but I'm giving you the money anyway. That's not how that's supposed to work. The bet never should have gone through. And you guys refresh my memory, but usually these were voided. I'm thinking back to the early days when we flipped the switch on the mobile betting. They were voided. People didn't get to keep their winnings. So I'm a little confused on how this is happening in this circumstance.
I think that's right, that they were voided. I think, as you said a little bit earlier, Commissioner, some discretion sort of to, make patrons happy. They sort of still let them keep their winnings. But it could, it sounds like it's a process issue of making sure everything is done in the right order.
Well, I don't know. Respectfully, it's a little more than a process issue, because it's allowing an illegal bet to basically follow through to its end is in violation of the statute and the regs. So to me, it goes beyond just process. Fundamentally, on this particular issue, given that it's done, we're trying to wrap up something on what appears to be sort of heading toward consensus on the civil administrative recommendation that you have. But I do think fundamentally we need to send out, they're voided, full stop. You go back to as if the bet was never done. And then it's a question of how do you make somebody whole?
Yeah,
if they want for the inconvenience factor.
Sorry, Mr. Chairman, sorry. So I'd be interested in some clarification, because I feel like I maybe have egg on my face now, because I did commend PSI on their response to this non-compliance matter. But is that something that, if it's the way they handled it is a violation of statute, is that not something that I mean, of course, that's something that the IEB is looking at as in terms of its investigation and recommendation. So where's the disconnect for me in terms of what Commissioner O'Brien is saying and what the findings of the report reveal?
So,
Benny, do you want to?
Sure. So I asked this specific question to Chris Soriano. I said, could you give clarification as to what was done with the bets? His response was, PSI did functionally treat all impacted wagers as if they were voided. That is they understood that that's what they were doing with their practice in this situation. So I was just reading an email exchange between he and I. So in their mind, that's what they were doing.
So maybe this is a wording in the summary of the action that was taken, because as I read the summary that was given to us, that's not how it was presented. It was presented as if the winning stakes and bets were allowed to go through.
So we asked more for clarification beyond that original point there. on the lost bets, because we were obviously most concerned with anyone who would have placed a wager and lost. And that received further clarification, which I have subsequent emails from that. But once I got the clarification here that they treated them all as voided bets, that was somewhat where I put my inquiry to bed on the winning wager. But I do agree. I think that perhaps we are some of the wording or terminology used is a disconnect. So
Yeah, and I would like further discussion on how we do this, though, because when it first happened in the beginning, they were voided. They weren't supposed to happen. And however, unhappy customers may be, look, it was an illegal bet. It never should have happened. Some of them went through because they were done in kiosks and nobody knew who they were, and there was nothing that could be done about that. So I think this is just a point that requires further clarification on our end and direction to the operators on what we want them to do.
I do want to turn to CEC Kramer. I see your mic's on.
Yeah, I was going to talk a little bit about some of the things that Nate already touched on. I think, as you said, Commissioner O'Brien, it's just something that we have to, when the non-compliance, and I think this is kind of what Caitlin was getting at, it's like the order of when things get to us and figuring out the information of going back to the operator to say, this is how you should handle something. And I know I've spoken with Carrie and Andrew about it on the sports wagering side of that being something that we flag almost initially when some of these non-compliance matters come in, of what happened with the actual wagers that were placed, and let's make sure that we're all on the same page about how they should be handled. So I think we're in a good place there. It might require some more clarification with the operators going forward, but I think I know there's been recent conversations because this issue, when we've reviewed it, I know sometimes even on our team we get confused of what happened to them, what language are they using, where did the money actually go. So I think it's just something that we're working to streamline with sports wagering and the operators to make sure that they're following the regulations as they come in here. I think in this case, PSI did allow the patrons that won to keep their money, but the ones that they that the individuals that lost, they basically gave them a cash credit that they were constituting as a void, and indicated that they could then remove the money from the account at any time. But I think it's probably something that would be good to send clarification to the operators as to what our expectation is with respect to that reg, as to what it means with a voided waiver. So happy to do so.
Yeah, it sounds like the commission.
Thank you.
Yeah, it sounds like the commission believes that these are void ab initio if they're statutory violations. So, Commissioner Broder.
I was just going to suggest, Commissioner, recognizing the corrections or that IEB understands what needs to be taken into account and communicated to all the operators. I would move at this time that we accept the recommendation related to this matter that the IEB has made.
Wait a second.
Second.
Thank you. Commissioner O'Brien.
So the only thing I would say is I almost want to condition it on further clarification in terms of how that was treated. But I just don't know how to ask to amend that motion to make sure that IB is going to do that and give a report back. It's not changing the disposition substantively. It's just asking for a report back to us, clarification on how that was treated.
Okay, so we have a motion and a second, so we would have to make a decision on that and then move on, or the motion could be withdrawn, or the second could be withdrawn, I guess.
Or I can move into, I don't know if it's because it hasn't independently been marked up, whether I can move separately to ask for a report back on that, or we can just mark it up.
Yeah, we can always take this vote and then you could make that second motion.
Yep.
Commissioner O'Brien.
With that understanding, I would say aye.
Commissioner Hill.
Before I vote, may I make a suggestion?
Yes.
Would Commissioner Broder be willing to withdraw his motion, and then he would make a new motion with the language if he thought that was appropriate? I don't know if he thinks that or not.
Or we can even take a friendly amendment on this report, right?
But the motion was already seconded.
It was already seconded.
Yeah, I'm saying to withdraw, remake the motion, and a friendly amendment could come. I was trying to make sure Commissioner Broder didn't have to articulate exactly what Commissioner O'Brien said, when Commissioner O'Brien can articulate it better than I can.
I am pretty comfortable, honestly, with where we're at, because we can ask the IEB to do that anyway. So however y'all want to go.
All right, Commissioner O'Brien.
I'm a nay on that.
All right,
Just
Commissioner Hill,
posturally.
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Aye.
and I vote yes. 4-1. Any follow-up on that?
No, I actually don't think it's procedurally appropriate for me to do it that way. So,
We can always add it to a future meeting and mark it up.
Yeah.
All right. Okay. Let's go to item B, sub-item B.
Yes, this is a non-compliance matter that's coming to the commission for the first time. So I'm just going to kick it over to Deandra to present some of the underlying facts. And just as a reminder, at the end of Deandra's presentation about the new non-compliance event, we'll be asking for the commission to decide what next steps they'd like us to take, whether that's setting it up for an adjudicatory hearing, referring it back to the IEB for further investigation, and obviously that last step that we haven't utilized yet, the civil administrative penalty process. I think it's in section 16 of 23N. So with that, I'm going to turn it over to Deandra to present this non-compliance matter.
Great. Good afternoon, Chair and Commissioners. This alleged non-compliance incident involves temporary Category 3 sports wagering licensee, FBG Enterprises, OpCo LLC, doing business as Fanatics Betting and Gaming, and implicates General Law, Chapter 23N, Section 3, 205 CMR 247.01 and the Massachusetts Sports Wagering Catalog, which prohibit allowing wagers on unapproved events. Fanatics offered wagering on a Boston College versus Michigan State NCAA football game scheduled for September 21st, 2024. The noncompliance lasted from September 15th, 2024 through September 20th, 2024. And during this time frame, Fanatics accepted 83 wagers for a total stakes of $3,325.88. The cause of the error was a manual override of offering limits by one member of the trading team. Fanatics voided impacted wagers, including already settled losing parlay wagers. Wagers that were previously cashed out by customers were not voided. At this point, I'm happy to take any questions, and I'd ask the commission its preference for next steps as to how to handle the noncompliance. And as a reminder, as Kathleen said, the options are to refer it back to the IEB, set it up for an adjudicatory hearing, or issue a civil administrative penalty under Chapter 23N, Section 16.
Thank you. Commissioner O'Brien?
So my inclination would be to treat it like the one that we just heard and send it back to IEB, but with the caveat that particularly with the summary of facts that you had, these are all supposed to be voided. And so I would like that to be part of the analysis when they do this.
I agree with the Commissioner O'Brien, Mr. Chairman.
I also agree.
Mr. Broders? I agree.
Great. I think we have our marching orders. I think that's it from Nate and Deandra. Thank you for your time.
Thank you. So the
Thank you.
final,
I appreciate it. Thank you both.
Chair, would you like me to move on to the third matter?
Yeah, I was just thanking your team.
So the third matter that we have today is going to be presented by Chief Monica Chang of the Financial Investigation Division, and this relates to the IAB's request for a waiver from 205 CMR 234.02, which I will let her explain.
Great. Thanks, Caitlin. Good afternoon, commissioners. So as Caitlin has said, the IED is requesting a waiver today to 205 CMR 234.02, where this regulation requires that sports wagering vendors provide 3 years of audited financial statements as part of its initial licensing applications. The waiver is largely for smaller companies who have not been audited before and thus could not provide all 3 years. This could be because they were never required to have audited financials or didn't have a business reason to. Under this waiver, instead of the 3 years, the sports wagering vendors would provide only 1 year, preferably the most recent year end, but with the commitment that they will provide the audited statements going forward for as long as they hold the license, so at future renewals. This approach is mirrored from how the IEB adopted a protocol under gaming, specifically under 205 CMR 13407, where only 2 years of the audited financial statements were needed from the gaming vendors instead of the 5 years. The reasoning for that protocol was that the smaller companies, for them to enter the casino market and to compete with other vendors, and for the commission to not create unreasonable barriers to entry. But at the same time, it meets our investigatory goals and overall responsibilities. So also under that protocol, in conjunction with the 2 years of the audited financial statements that they have to provide, the financial investigations team conducted our own verification of certain accounts of the other 3 years of the unaudited statements as part of their application. On top of that, place reliance on reciprocity with jurisdictions that also takes an audit approach. So this overall protocol has been in effect since its adoption in 2017 when it was approved by the executive director at the time. So based on that protocol under gaming, the IEB has developed a similar approach for the sports wagering vendors, which culminates into the waiver request that we have today. So happy to answer any questions or go through any details the commissioners have.
Thank you, Monica. Commissioners, questions? I think we need a vote on this one. There are no questions.
Mr. Chairman,
Commissioner Hill.
I move that in accordance with 205 CMR 202.032, the commission issue a variance to new sports wagering vendors from the requirements outlined in 205 CMR 234.021F, as granting the variance meets the requirements specified in 205 CMR 102.034 and is consistent with the purposes of Mass General Law, Chapter 23N.
Second.
Thank you, Commissioner Broder. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Broder.
Yep, yes, excuse me.
And I vote yes, 5-0. Thank you to Chief Chang, and hopefully we gave you what you needed there.
Yes, definitely. Thank you very much.
Director Monahan.
That is everything we have for you today. So thank you.
Thank you. Thank you to CEC Kramer and all the rest of the team. Commissioners, we already tackled number 9. And so what I'm going to do is, if you'll allow me to, I'm going to go out of order. Number 11, Commissioner updates. Do we have any Commissioner updates? All right. Do we have any other business that we didn't anticipate? All right. We have some executive session minutes, which are under number 10 that Secretary Skinner is going to bring up. And so for that, I'm going to read some language into the record. And if we so choose to move, we'll do so. The commission anticipates that it will meet in executive session to review minutes from the previous executive sessions at their discussion at an open, as their discussion at an open meeting may frustrate the intended purpose for which the executive session was convened, pursuant to General Law, Chapter 30A, Section 21A4, Chapter 30A, Section 21A7, and General Law, Chapter 4, Section 726F. May 30th, 2023, General Law, Chapter 30A, Section 21A3, and General Law, Chapter 30A, Section 21A6. September 21st, 2023, and General Law, Chapter 30A, Section 21A7, General Law, Chapter 23N, Section 6I, and GL, Chapter 4, Section 726N, December 16th, 2024. And those are May 30th, 2023 again, September 21st, 2023, and December 16th, 2024. Would we like to enter into executive session?
Mr. Chairman, I move that we enter into executive sessions for the reasons you just stated.
Second. Oh, I think Commissioner Broder got that one. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Broder,
Yes.
and I vote yes. To the public, we will not re-enter public session. We will end in executive session, and we hope that everyone has a good Thursday.